Sorry about that. The mic wasn't on. I came on really fast tonight. Unexpectedly, the court for the George Kelly trial just posted their streams from today. And I have a 3 o'clock hard stop tomorrow. So tonight we're going to watch the morning version. This happened earlier this morning. However, I'm hoping that tomorrow we'll get to go. Sorry, I got something in my eye. We'll get to go to actual jury tomorrow. So we'll see what happens. So right now, I'm not going to delay this at all. I'm going to go ahead and get us going on the actual hearing. Why is it not showing up? Let me refresh. Sometimes we have to do that. Oh, my browser. Why will it not allow access? What? Let's just close out of this. We'll just close that out, and let me see if I can reopen it. So what's happening is that we're talking to the sheriff, and the sheriff was on the stand today and yesterday. And so we are interested. I think I'm gonna slice this another way. Let me pull that. Let me go. I'm going to get it directly from the state. I'm not going to get it from YouTube. I'm going to get it directly from the state's website. Yes, I am so lucky. I have their actual. There we go.
And we would see what came up at trial.
Okay,
All right, fair enough. I just want to get that on the table.
Okay, so what's happening is that the retired sheriff was on the stand yesterday. At the end of the day, he will be back on the stand today. And then what's going to happen is that he will be, we will be getting others in testimony. I don't even know who's up on the slate for today. The judge is going to be discussing things with the jury right as soon as we start. Thank you for joining. Please comment, like, and subscribe and share. So what's going to happen today is this evening. The judge and the lawyers are going to be discussing the fiasco that happened. Oh my gosh. I might as well try and find it. The judge got absolutely hissy in this trial. And let me tell you, it was something to behold. I'm going to play this.
On the Kelly Ranch in January of last year. 13 News reporter J.D. Wallace explains what has the judge leaning on attorneys.
This was not pretty well. I'm going to fast forward all this. Here we go.
The state was expected to rest last Friday, and that has yet to happen.
So clearly, we are behind schedule. This case is going to go to the jury next week. It's going to go to the jury next Thursday. And I'm going to move this case so that happens. And I'm going to start imposing time limits.
The state is expected to rest tomorrow. The defense is expected to need 2 days for its witnesses, including Santa Cruz County Sheriff David Hathaway and possibly George Allen Kelly himself. From Nogales, J.D. Wallace, 13 News.
Okay, that didn't show you what it all happened, but what ended up happening was the judge told them, "Oh, you're going to have 5 minutes to cross-examine this." And what happened? The defense side objected to the judge's behavior. Basically, what's happening, he's saying, it's taken too much time. I got to start putting time limits on the cross-examinations and the redirects. The problem with that is that the prosecution has been on, literally has been on for 3 weeks now. and they said the whole trial was going to take 3 weeks. The defense hadn't even gotten the case until Monday of this week, and this was last Thursday, I believe. The judge had told the defense, and they were about ready to cross-examine one of the key witnesses in this trial, and he said, "Guess what? You can only get 5 minutes. I'm not putting up with any more of this unlimited cross, etc. ... And so, oh, I didn't have music. I'm sorry. And so she objected. When she objected, it was a strong objection. The judge got really irritated and dinged her down to 4 minutes, and it really got nasty. So the judge has kind of brought himself back into some senses. So let's get into trial. Here we go.
Back on the record, show the presence of counsel and defendant. The jury's absent. Before we bring the jury in and continue with the cross-examination of the witness, a couple of things I just wanted to hear from the parties about. First, when we discussed the additional possible witnesses for the defense, I might have missed it, but I don't recall Detective Barba's name. But the courts limited additional cross-examination by the defense of Detective Barba. But I did rule and intend to obviously honor the ruling that you could recall Detective Barba in the defense case and examine him and use leading questions, whatever, with respect to whatever remained. So I just wanted to make sure that that was still understood to be the ruling of the court, and that's still there.
Yes, we understand that, Your Honor.
All right, and you're not intending to call Detective Barba?
We haven't decided yet. He's out there. If we get what we need from the other witnesses, then we won't.
Okay, very well. So that should resolve that issue. Now, also, the court recalls that with respect to the current witness, Sheriff Hathaway, there was a motion in limine that was filed, I think, on behalf of the state with respect to that witness. And I don't think we got to that as part of pretrial rulings, but I just wanted to anticipate an issue. Maybe there is no issue. What's the state's recollection? Then I'll hear from the defense.
Your Honor, I think the defense has already started to cross-examine or to question him with respect to whether he was legally authorized to do what he did in Mexico. I mean, clearly he was. Clearly he had legal justification. I don't think that's relevant to this case anyway, because if he did something wrong, that would be a separate issue anyway. It has no bearing on the interview with Daniel here. So I would ask that we not go any further into that at this point, or that the court instruct the jury that it's not relevant.
All right, well, what my intention was, I'll hear from the defense, my intention was, questions have been asked, I didn't hear any objection, but just to deal with it on a question-by-question basis and see where you go.
Yeah, my recollection was we discussed that motion, and that's essentially what your ruling was that I was allowed to ask the sheriff questions, and we would see what came up at trial.
All right, fair enough. I just want to get that out on the table so we didn't let something like that fall through the cracks.
Sorry, my mic was off.
All right, if there's nothing else, then we can bring in the jury. Thanks.
Mary, let me see. No. I just went on. It's day 15. Sorry. Baby girl, I know you're such a good girl. Okay, they're waiting for the jury to come in. So the gentleman that's getting on the stand is a retired judge. Not a judge, sorry, a sheriff. And unfortunately, he actually had some very harsh words about Mr. Kelly. He called Mr. Kelly a vigilante. He really ripped him a new one in the media before the trial, which I thought was very inappropriate and unprofessional. He is now being called as a defense witness, kind of like a um, hostile witness. It's been pleasant
Thank you,
thus
everyone.
far.
Please be seated. The record will show the presence of all the jurors, counsel, and the defendant, and we can have the witness retake the witness stand, please.
But it's going to get a little hairy in here. I would not be surprised if it did get a little difficult in here with this gentleman, because he's no longer a sheriff. He is retired, but he went into Mexico as when he was a sheriff in
Morning,
civilian
sir. Retake
clothing.
the witness stand.
Did not make any
Thank you.
arrangements like he was supposed to. I think there should be some charges brought against this guy. He definitely broke the law. There is some laws about that in this country and even in Mexico.
All right, the witness is back on the stand. I always inform every witness who's had a break over the evening that you're still under oath. Okay, very well. And you can continue with your cross-examination, Ms. Larkin.
So I want to talk some about this interview that you did with Daniel
Correct.
in Mexico. Prior to meeting with him, what can you summarize the background information that you
This is
had
a
about this
supposed
case?
witness in the case.
There's probably a lot of things more than I can summarize, but that there was a killing on January 30th of 2023 in the Keno Springs area on a property that pertained to an individual named George Kelly, and that evidence had been collected at the scene. Shell casings and a body had been recovered at the scene. I was informed about various 911 phone calls, various other communications with Border Patrol, with ranch liaison officer. I could be missing some things, but that's it in a nutshell.
Did you know where the body was located in relationship to the house?
No, I do not.
Did you know where the
Did not
house was located in
see.
relationship to the border wall?
No, ma'am, I do not.
Did you know about other witness statements before you met with Daniel?
I had heard some things. The summary of the 911 calls.
Sorry for the camera.
Had you
shaking all
reviewed
my-
a
my
statement
dog did it.
provided by a person calling himself Miguel?
I don't recall that.
Had you reviewed a statement provided by a person named Ramon?
No, I had heard about Ramon, but I didn't review a statement.
So you weren't aware of what either of those people had said?
That's correct.
And we talked yesterday about some of the ways that you test the credibility of a witness, right? And what you said one of those ways was comparing a witness statement to other witness statements, right? And another way was comparing a witness statement to the physical evidence, right?
That's correct.
Without knowing the content of those statements and without knowing the facts on the ground in this case, how were you planning to test Daniel's credibility?
I know probably as one individual more than anyone else in the sheriff's office about the overall aspects of this case, since I am the sheriff and I was briefed continually on it.
I have to stop. I have to stop. I'm so sorry. That is so much. I he knew nothing about this case other than hearsay. He did not go out to the ranch. He did not attend the autopsy as far as I am aware of. He was not an active part of this. He would get some information. He'd read a report here and there, but he was not involved. He was, oh my gosh, that's such a lie. I need a button that goes, liar.
I did not go to the crime scene, but I can
Thanks
test,
for
for
admitting that.
example, that Daniel said that an AK-47 was fired, that he recognized the sound, and I know that an AK-47 was recovered and shell.
Guys, if you have an AK-47 being fired, and then you compare it with an AR, if they're not in the same place at the same time, most people can't tell the difference between an AR, AK-47 when it's fired. And the witness Daniel he's talking about said that, oh, I knew it was an AK-47 because they shoot them off at Christmas. That is a load of crock, y'all. He heard a shot. You cannot say with 100% accuracy that that was an AK-47 unless you've been in the military and you've been in that situation, you were trained or whatever. This guy had nothing. Oh, y'all. The is getting deep.
Casings from an AK-47, so that's one example of testing
Real deep.
what he said. Another example was a horse, a reddish colored horse that he said saved his life, that was running next to him when the shooter was on the opposite side of the horse shooting at him. So there was a horse.
So I don't want to get into what he said to you specifically, but
Here's
I just
say,
want to
you know better.
understand what you had available with you to test his statement. You know some facts about the case, but you don't know where the property is. You don't know where the body was located, right?
I know where the property is. I didn't go there, but I know generally where it is.
You don't know where it is in relation to the border wall.
Generally.
Okay. You don't know what position the body was found in when he died, right?
That's correct.
Because you didn't go.
You know that a horse was not shot during this incident, right?
That's what I was told, that a horse was not found shot.
Okay. Another way to test a witness's credibility is to provide photo lineups, for example, right?
That would be correct, yes.
And to see if they can make an identification, right?
Yes.
So one way that Daniel's credibility could have been tested would be to provide a photo lineup, including Mr. Kelly's photo and other photos of other people who look like him, right?
Well, on the date that Daniel showed up, which we didn't know if anyone was going to show up or the name of the individual, we didn't know the nature of the beast. We didn't know what we had on our hands. So we were doing this in Mexico. We didn't have every investigative avenue available to us, nor did we know what would come up in his statement that we would need to compare with.
So you weren't prepared to even try to get him to identify somebody?
We were prepared. We did
crap on
ask
this.
about the individual that was doing the shooting.
Did you bring any photographs?
We need to let the witness answer the questions, please.
Can you repeat the question? I can't remember what it was.
Did you bring any photographs with you to try to let this witness make an identification
No,
on
not that I
photographs?
recall.
You had photographs of this other witness, Ramon, correct?
I don't know. One of the detectives may have had photographs of him.
Did you bring any photographs of Ramon to try to do a lineup of Ramon with this witness, Daniel?
No, I did not.
That would be one way to test his credibility, right?
That would be discussing one aspect of a thing that didn't directly involve the shooting. Was Ramon was not alleged to be at the shooting. Only two individuals, Gabriel and Daniel.
You didn't believe Ramon was alleged to be at the shooting?
Not from what Daniel said. He said there were two individuals. The group scattered at Duquesne Road. Two ran back to the border, which was Gabriel and Daniel.
So, and you hadn't reviewed Ramon's statement. I understand that. Detective Barba had interviewed Ramon, right?
I think that's correct, but I don't remember for sure.
Were you aware that Ramon was also claiming he was at the scene of the shooting? He was there.
I was aware that he was alleged to be part of the initial group of 7 migrants that came in going towards Duquesne Road, which was referred as the road to Washington Camp or Mount Washington. And then when they saw a Border Patrol vehicle, they scattered, and only the 2 individuals were on the area where the shooting happened on the return. That's what I'm aware of.
And you're aware of that because Daniel told you that. Is that where that came from?
Well, that would be one way that I was aware of that.
What was the other way you were aware of that?
Exactly. And are you aware of how much water they
I
were
don't
carrying?
know.
Are you aware
That's
of
just
how
what
many
Daniel told
weapons
you.
they were carrying?
That's what
Probably, right?
Daniel told us.
Okay. So if I told you that Ramon said he was there and he saw this shooting and he was with a whole group and the whole group was present when this shooting happened, that was his statement. That would be something that you would try to compare to Daniel's statement to test his credibility, right?
I'm not aware of what Ramon said.
If you're going to test a witness's credibility by comparing his statement to somebody else's statement, you should probably be aware of the other person's statement. Shouldn't you?
If a person had the mechanism to do that, I didn't know what I was going to encounter in Mexico on February 15th. An individual did show up. I didn't know who they were going to be or what they were going to say. So I documented what they said.
And you didn't do anything to test his statement against other statements that had been put forward in this case, did you?
I know the detectives were working on this case, and I'm aware that they did that type of thing, pursuing many different avenues beyond what I pursued. So they were doing those kind of things, comparisons.
Which detective did that?
I don't know.
Did you ever review a report from any detective that compared these witness statements to each other?
I don't recall reviewing a report that did that particular thing.
Is it possible that nobody did that?
I don't know. I didn't review all the reports in the case.
Not only you don't have reports, you didn't record
During this interview with Daniel, we know this other witness, Ramon. He was out there before. Do you recall Detective Barba providing his name to Daniel?
I do recall Detective Barba providing his name to Daniel. Yes.
And a better way to test Daniel's credibility would be to ask Daniel who else was with you. Wouldn't that be a better way to do that?
It would.
I do know that he did describe there was a group of 7. They were scared when they got to Duquesne Road and saw a Border Patrol vehicle, and then 2 of them ran back. So I know he did it.
Okay, we are getting ready to have an impeachment. If they don't catch this, I'm going to be angry. The witness, Daniel, when he was on the stand at the latter part of day 1, early part of day 2, made a comment when asked, "Did you see Border Patrol?" We was specifically asked if he saw Border Patrol. He said no. They heard a car. They were told by somebody in the group it was Border Patrol, i.e. the Coyote. It had this here is inaccurate. Once again, the sheriff who's on the stand over a month later made his documentations of this meeting. He didn't document anything. He didn't record anything up until the last 6 minutes of the interview. They met in a restaurant in a hotel. It was noisy. It was too public, they say. Then they went to the lobby. He interviewed these witnesses in front of the 2 daughters and the uncle of the deceased. And he went across the U.S. border illegally.
Description of who was there. It was a group of 7 originally, and then it was weaned down to a group of 2 after everybody scattered.
So that wasn't my question. My question was to test Daniel's credibility.
Right,
If you
yeah.
have another witness who says he was there, rather than providing that witness's name to Daniel and saying, "Do you know this guy?" A better way to test his credibility would be to ask Daniel, "Did you know anybody else in the group? And if so, what were their names?" Would that be a better way to approach this interview?
And to interview them in an
I don't know,
individual
that's,
room with a recording and not in the
Detective
middle of a
Barba was aware
restaurant
of the
or
name
cantina.
Ramon, so he did ask
Oh.
about that name, and I don't know if there was better ways to do that.
It's pretty suggestive to just provide another person's name to a witness in an interview, right?
Well,
Yes.
that was a piece of the case that Detective Barba was aware of, and so he asked that question, and I don't know if there would have been a better way to do that.
My question was, is that suggestive?
You've
Thanks
already
for
answered that
commenting.
question. He said he doesn't know. So that's the answer.
Okay.
Let's move on.
Did you later, so after you did this interview with Daniel, did you record a portion of this interview?
Yes, I did.
Tell me about that. What did you not record? What did you record and why?
I would say the whole encounter was possibly, this is an estimate, 45 minutes to an hour. I think that video recording was 6 minutes and 40 seconds. So it was a summary, just a thought I had at the end of the interview. If something happened to this witness, if he disappeared, if he wound up getting killed.
If this person was interviewed in the United States or even at the port of entry, at the port of entry, you can just take them into one of the interview rooms that they take people in all the time to interview them about whether, when they catch them with things and all that, where there's cameras, everything you need. He said, well, he was not a U.S. citizen. He wasn't a Mexican citizen. He was a Honduran citizen. That was the reason why. And the fact that he knew, i.e. Mr. Huffman, the sheriff, retired, knew that going into Mexico in plain clothes, not informing anybody of what he's doing, taking one other deputy with him, meeting these people in a restaurant, and talking to potential witness in front of other people, and even in front of another potential witness? I can't even believe they got a grand jury to indict.
I wanted to have something other than my word and Detective Barba's word that we had actually talked to the witness. So it was
And
a
you
summary
should have recorded the entire
of the events
interview.
of that day. And I'm sure there were things covered in the overall interview that wasn't recorded that are not captured in that video interview.
So you spoke with him for
Your sheriff,
a
you
while
should know
and
better.
then recorded this 6-minute portion after you had substantially finished the interview.
That's correct. Before departing, just wanted to create evidence that this encounter had happened.
Why didn't you record the whole thing?
Thank you.
Didn't think of it until we were at the end.
You didn't think of recording a witness interview?
I
Come
didn't think of
on,
that.
you're
I
a
think
sheriff. You know all the
witness
rules.
interviews on the street are not recorded or not video recorded, but I did just
You
think
have
the
body
nature of this
camera.
individual, he didn't have legal documents to come into the U.S. Just thought, is there a possibility I'll never see this witness again? Maybe it would be good to do a summary, a little video summary to show that we had actually met with an individual.
It's standard practice to record witness interviews.
And
Right.
Not necessarily in my career. Most witness interviews are not recorded.
When you pre-arrange a witness interview and you have time to plan to do the interview, is it best practice to plan to record that interview?
This was an ad hoc situation where somebody may show up. Juan Carlos Rodriguez said he would try to arrange an encounter with this individual. I grabbed a detective. I went to the location to see if anybody would show up.
Sir, do you have a cell phone? I mean, come on. You guys are in the legal force. You're in the police force. Hello, do you not have a cell phone? This is why you shouldn't have gone over there illegally and not taken the guy to the taken the guy over to the police, to the Mexican police, or even over to the port of entry. And the reason why, because you were scared that they would find out that this guy was an illegal and you would lose a potential witness because he's an illegal Mexican. He's Honduran. He got up on the stand Monday, the first day in the afternoon, or even the second day in the morning, and flat out said, I'm terrified to be here. And you even had the district attorney trying to get the judge to order this guy not be on camera and to not record his voice for the fear that he was going to be caught by Mexican police. You didn't want his name used. You didn't want his face used. You didn't want his voice being recorded. You did not want that part of the court hearing public because he was afraid that he would be deported back to Honduras. I wonder if he has. And you know this guy has come in to the United States illegally 9 to 10 times by his confession and got caught once carrying drugs and served jail time for it in the United States and then was deported. I tell you what, if this guy was sheriff in our county, he'd be hung. Not physically. He would lose his office.
And we weren't at our office. We didn't have the full range of equipment that we would have at the office.
You don't need
We
it.
have like a forensic team with us. It was just me and Detective Barba.
You have a phone.
And we just did the best we could in Mexico.
I don't, you shouldn't have
just
been
doing an
there.
interview with this witness that did show up.
You had your phone with you,
That's correct.
and you used it to record a portion of the interview.
I
That's
love it
correct.
when I think.
Why didn't you just use it to record the whole thing?
I didn't think about it.
Think about it. You're so full of it.
Who is Big Super?
He has a YouTube channel.
Is this a person that you talked to about this case?
Oh,
I talked to
Objection,
him.
Your Honor. Relevance.
All right, this is something new, so let's have
okay,
a
y'all are they're gonna have to put their little ears on again, so we're gonna have to go into music. Okay. He did an interview with this person calling the defendant a vigilante and saying all kinds of stuff that is super no. You are the sheriff. You may have to testify in this case. You went to Mexico illegally. You are a hot gun and you're not sheriff anymore. You retired. I wonder, did you get in trouble for any of this? I want to go and do. I'm having some glitchiness on my keyboard, so I'm going to have to maybe send it back and do without it for a while. But oh, my ever-loving Tushy, how in the world? This is when my Mr. Goat, and we need to have a naming contest for the goat. The muckery that is going on with this guy. The muckery. I'm going code red. He done did it. He done did it. I'm going code red. Am I red? Yes, I'm red behind me. Maybe hard to see, but it's red. I am absolutely appalled. Did I go right? Yes, I am right. Yay. I am trying. Anybody know how to connect these things? I'm trying to get my lights to connect, and I had somebody helping me, and they just kind of disappeared on me, which was a shame because I like the dude, but I need someone to help me with lighting. Big time help me with my lighting. Because, well, maybe if I'm smart enough to figure out this, I can figure out lighting. But we are red. We are code red. This sheriff. How many years have you been in the police force? How many years were you a sheriff deputy? If I was him, I would be scared to death that they are bringing up this. I hope the judge lets it in. Then the prosecution is going to fight tooth and nail to keep this out, y'all. Because what's happening is that they have video of this sheriff slamming the defendant and just publicly butchering this guy before trial. You want me to name the goat Cooper? All right, Mary. Cooper the goat. I could do Cooper the pooper. I'm sorry, that's tacky. I'm floored. I am actually floored. You know, I have waited this entire trial for the you're guilty moment from the prosecution and didn't get it. I have a lot of reasonable doubt, but this right here just nails all reasonable doubt for me. It nailed it. If I was on the jury, I didn't adjust this. Y'all, I hopped on so fast it wasn't funny. I have a hard stop at 3 tomorrow. So I'm doing the morning session now. And then tomorrow morning, I will do the evening session, afternoon session, unless they went ahead and went to jury. But I am. Boy, this has taken a long time. So they're really fighting over getting this in. I think they should get it in. It's public information. It's publicly downloaded. It was all over the internet. I wish I knew the people to pull the video for you. I'll find it. I gotta find it. Oh, wait. Let me look. Let me look at the state of Arizona's oh, I already had it up. Why did I do that? I'm going to look at the state of Arizona's minutes from today because I can see if it was entered in as evidence. Okay, so he didn't stay on there but an hour today. I don't think that. I think they rested today. Oh, something was not allowed. The state was not allowed to come in. So everybody rested today. So it looks like we're going to go to jury tomorrow. Okay. Mr. Kelly is not testifying. He doesn't need to. I would agree with that. I don't think he needs to. Okay, so yeah, they didn't say in the minutes. I'm blessed. I have the minutes. I'll go ahead and share the minutes with you guys so you guys can see it. Here are the minutes. I wish I got to learn how to make everything bigger. I don't need this. Okay, can I make this bigger? There we go. That's the biggest I know how to make it, y'all. So they did rest. So it looks like that David Hathaway is going to continue, and then Raul Rodriguez is going to continue, and then after that, out of the presence of the jury, Mr. Kelly was advised of his rights to testify. The defendant affirmed the statement and informs the court he will not testify. The parties discussed rebuttal. The jury panel now present in court resumes session. At this time, the defendant rests, and at this time, the court stands in recess for lunch. So we're going to go ahead and we're going to go ahead, and I think what we're going to do is we're going to go ahead and run it, and then tomorrow I'll do a synopsis of the trial, and I'll show different things. So I think that's what I'm going to do. And I noticed, y'all, when the trial was happening in the beginning of, up until about yesterday, there was only 10-15 in court. We have 2, 4, 6, 8, 10, 11, 12, 13, 14, 15, 16, 17, 18. We have everybody on one side. This whole side was the entire courtroom. And then over here, you got a lot more. So hallelujah, we're getting more people. Oh, I don't know why I'm doing this. Duh, I forgot. I'm recorded. Wow, this is a very long sidebar. Okay. I'll have to in the notation on that. Okay, let's go live. They'll come back in just a second.
All right. The court's ruled at the sidebar, and you may proceed with your direct examination. Excuse me.
Yeah,
Did you make comments to Big Super about Mr. Kelly's case?
She won.
As the public information officer for the sheriff's office, I try to be transparent and talk to anybody. This Big Super individual wanted to do a border tour, And while we were doing that border tour,
Oh, I've seen clips. You're
he
so
asked
full of it.
me, what about vigilantes? Do you have vigilantes on the border? And I gave an answer,
He answered everything without saying Mr. Kelly's name, but talked about the case.
which I didn't say Mr. Kelly's name. I
I'm
said,
gonna
we
see if
have
we
a
can find that
situation
video
where
so
there's
I
a
can-
rancher that shot at 2 migrants and killed one of them, and the other one got away. I did mention that incident, and I didn't say the name George Kelly in that interview.
Did you say that he just wanted to go hunt him some Mexicans?
No.
Yes, you did.
After that comment, I did segue into a collective pronoun, the word they, that there is a type, that they want to go hunt themselves some Mexicans. They
There
want
it
to
is.
have the
I found it.
mystique of the Old West and the border, get some excitement. And we've had individuals that do that. Like
We're
there
gonna
was one
watch
called
this
Take the
tomorrow.
Border Back, a group that just came in not too long ago, a bunch of armed individuals. I told Big Super that this was rare. It was
We
not
are
common,
watching this
but it does happen
tomorrow.
occasionally.
You told Big Super, we caught this rancher shooting at migrants. And
Yes.
then you said that there are people who want to come hunt some Mexicans. You made that
Yes.
statement.
Yeah, I just did a kind of colloquial. There are some people that they want to go hunt them some Mexicans. Yeah, I did say that statement.
Right after referencing Mr. Kelly's case.
And I didn't mention Mr. Kelly, but I did generically refer to a type that has that attitude.
You didn't
You
say
referred
Mr.
to
Kelly's
him. I
name, but
watched
that's who
it.
you meant, right?
That is who I meant.
I'm watching it now.
You also tell him something about pet ranchers. What did you say about pet ranchers?
Something to the effect that there are ranchers that are on speed dial for certain news outlets that they will interpret everything as a crisis, as that foreigners are hostile, foreigners are here to do us harm. So I did reference that there are people that can get on the news by talking this sort of crisis mentality, hostile nature of foreigners, rather than them just coming here to work, but that they're here to
This
cause
video,
harm.
he is showing off his.
And your implication was that that's totally
grandfather
exaggerated.
clock, His home. He's
That's
parading
exaggerated?
his ranch.
What the ranchers are
His
saying,
mouth
exaggerated, right?
Yeah, that's my
Okay.
implication.
Who cares about you whining your grandfather clock in the video? We're going to watch this tomorrow.
You talked yesterday about how you don't really get involved in a lot of cases, even the major ones. I just want to ask you, why did you involve yourself in this case?
It was mainly because of the specific nature of the Mexico interview. And I had done so many interviews like that when I worked with the DEA. And I've been going to Mexico my whole life. I was born in Nogales, Arizona, grew up here in Nogales, Arizona. I've been going to Mexico my whole life, in addition to my DEA career, which was largely in Latin America. So it was easy for me to go and talk to an individual in Mexico, whereas for others, they may be reluctant to do so. So it just seemed like a natural, easy thing for me to do.
That's the only reason?
Oh, this cord, I got to get an extension on it. You guys, I was watching that video. I pulled it up. Yeah. I would love to see the defense play the video, because let me tell you, it's very, very, very condemning on his end. And if you work for the DEA, then you definitely know about interviewing you. Oh my God.
Yes.
I don't have anything else, Your Honor.
Cross-examination from the state.
Cooper?
Yes, Your Honor, real briefly. Sheriff, let me ask you the question about the report and the video, or the video recording and the report,
Yes.
right? You recorded via a report, right? The interview.
There was an interview that happened, and then at the end of that interview, I synopsized the interview in a video recording.
And there's a report on this, right?
There's a report about the entire interview. That's correct.
That he
Detective
filled out
Barber
over
was
a
with
month
you,
after
correct?
the
That's correct.
interview.
Detective Barber is one of the detectives on this case, right?
That's correct.
So if you had any questions or concerns, Detective Barber is there to assist you.
That's correct.
And you talked about, are you familiar with the where the victim's body was found in relationship to the Kelly home?
I'm not aware of the specifics.
Are you familiar with, comfortable with 115 yards?
I'm not aware of the specifics. It's only is what I've been briefed. I've
Then
been
why
briefed
are
that
you
number,
doing
but
an interview
it's
if
just
you're
based
not
on a
aware of
briefing.
the specific?
Well, let's just I'm going to give you a hypothetical. If someone's standing
You
115
don't
yards
have the
away
facts of the
and there's
case.
brush, is it easy to make an identification on somebody? If you're
Easy.
115 yards away, there's
It
brush.
It
Is it
depends
easy?
on the nature of the terrain.
You're digging yourself in a hole, dude.
I have a ranch in that same area and I know what the terrain is like, and it depends. There could be mesquite trees or things between the individuals, or it could be
The
open space.
prosecution
It's hard to say
said,
without actually looking at
okay, here's where I get upset with the prosecution, and I hope the jury catches this. Once again, Daniel, the star witness for prosecution, who is an illegal immigrant in Mexico and in the U.S., stated that he could identify Mr. Kelly from over 115 yards away. Actually, more than that, because he was 115 yards away, supposedly, when the victim was shot, and he ran back towards Mexico, another football field length that's 200 yards away, and says he can identify Mr. Kelly. But your sheriff, who has land in the same area with the same terrain and everything, saying, I don't think so. Not necessarily.
the crime scene.
And also, too, have you
Mind
ever
blown.
been shot at with an AK-47?
No,
Do you have a lot of officers under your employ that has been shot at by an AK-47?
no.
Not everybody carries an AK
Also, too,
47.
the questions about credibility with
They have
Daniel.
found
in
handguns
Mexico.
laying all over the
One
ground.
of the things you talked about was you knew something about the case, so you're asking Daniel to tell me your story, right?
That's correct.
And you're checking that mentally with the facts that you know that Detective Barba or Detective Ienza told you about the case, right?
That's correct.
You gave a
Once
couple
again,
examples, right?
The telephone
Yes.
game.
One example was a horse.
Hmm.
Did
Say
you
yes?
ever interview
Yes.
Mr.
One
Kelly?
example was AK-47 being shot.
Correct.
So in your opinion, did Daniel seem credible to you as you interviewed him on February 15th?
Objection, foundation, and argumentative.
Sustained.
Not only that, y'all, he didn't check his ID, and the guy said, the witness, Daniel, that he had an ID for Mexico with the wrong last name on it because that's what the Mexican government gave him, which is a bull-faced lie. Because then he turned around and said, I'm an illegal in Mexico, and I'm worried that by testifying, I'm going to be deported back to Honduras from Mexico. The ID he had was probably given to him from the cartel, or he paid somebody to make him a fake ID. And the sheriff never investigated the identities, never validated the identities of anyone he met with. I know my pitch is getting high because I'm getting irritated.
Redirect.
I don't have any redirect.
Thank you.
Oh,
All right, ladies and gentlemen of
snap.
the jury, any questions from the jurors for this
Sheriff is
witness?
done.
Appears we have more than
Thank
one,
God.
so we'll go to the bench conference.
Thank you for commenting, liking, and subscribing. I greatly appreciate it. Oh my gosh. Oh, we got this again. So the defense won the last sidebar. I will show the video tomorrow. I saved it. That video is going to be showed, and you're going to be appalled at what the judge says.
Mark this Hathaway number 1.
Oh, we can hear.
Sheriff Hathaway,
Oh,
you
Mike
and
is
Mr.
on,
Kelly
dude.
know each other, and if so, please describe your rapport.
Your Honor, your mic is on.
Same juror, did you involve yourself with this case for political gains?
You should have interviewed the horse. I love it. I'm leaving that up.
That's Hathaway number 1.
Oh,
Let's see. There's Hathaway number
snap!
2.
The mic is still on. I wonder if anybody's hearing it other than us.
Two questions. In your testimony, you stated that the county attorney's office and your deputy sheriffs were nervous about going to Mexico
We're not supposed to
interview
hear
a
this.
potential witness. I'm still not clear on why they would be nervous unless it was not a legally authorized method to interview a witness in another country. Can you please explain again?
Y'all,
Second question.
Mr. Kelly's going to be found innocent. I would be utterly shocked and dumbfounded.
Same juror. Based on what you know today and based upon your evidence with Daniel, do you believe he is a credible witness? All right, I just sustained an objection to that question.
So we
I'm
can't
gonna
ask that one.
question. I already sustained an objection to that question. Okay, this will be Hathaway number 3 from the third juror. Can you state if Daniel Ramirez was left or right-handed? If he knows. Second question, same juror. During interview with Daniel, was he wearing any what seems like new clothes, shoes, jewelry, or electronics? All right, that's it. Question from some of the jurors. Sheriff Hathaway, do you and Mr. Kelly know each other? And if so, please describe your rapport, or I would assume your relationship.
My family has a large ranch in the same area, Duquesne Road, Keno Springs area, as Mr. Kelly's property. So it's possible that I've met him, but I don't recall specifically having met him in the area while working on the Hathaway Ranch.
Second question, did you involve yourself with this case for political gains?
No.
Yes.
Additional questions from an additional juror. In your testimony, you stated that the county attorney's office and your deputy sheriffs were nervous about going to Mexico to interview a potential witness. I'm still not clear on why they would be nervous unless it was not a legally authorized method to interview a witness in another country. Can you please explain again?
Just speculating. Maybe they hear about the danger in Mexico, that it's dangerous down there and they don't want to expose themselves to that kind of danger, but I don't know
Jerry,
exactly
I'm going
why.
to think off the top of my head and come up with the stupid answer for you. They work on the border. They deal with the Mexican police all the time. They deal with the drug cartel. They deal with the illegal immigrants, coyotes, and everything under the sun, and are very underpaid. And they have more sense than you do to not break international law.
And question
Sorry.
from another witness. There was another question from that juror, but I had already ruled on that question
Not.
before, so I won't ask that one. But another question, two questions from another juror. Can you state if Daniel Ramirez was left or right-handed, if you know?
I don't know.
Why?
Another question from the same juror. During the interview with Daniel, was he wearing any what seems to be like new clothes, shoes, jewelry, or electronics?
He's not going to give the truth.
No, not that I recall. He was dressed humbly.
All right, those are all the questions from the three. Any other questions from the jurors? All right, we have another question from a different juror. Let's get that. We'll go on the sidebar for that.
Let's see if he forgets to turn that off again. Yeah, let's see if we hear him this time, because normally we can't hear the judge. Yeah, he's turned off his mic. So we're not going to hear it. I know I'm getting a little tissy with this, y'all, but this is absolutely mind-boggling. I will pull up. I want to make myself a note. I'm going to pull up the law concerning this. I'm going to pull up the international law between U.S. and Mexico about investigating over the border. I did look at it. I did read it before this case began, and that there is law set in place to where you cannot just go over across the border.
All right. We are back on the record. I made some rulings
Can't
that
go here, we can't go
to the
there.
effect that part or some of these questions will not be asked because they may have been asked and answered or for other reasons. But witness having answered questions that I've allowed from the jurors, is there any follow-up questioning to the questions of the jurors from the defense,
No, Your Honor.
from the state?
Yes, real briefly, Your Honor. Let me talk about, there's a question about the attire of Daniel. Your answer was humbly.
Correct?
Does Daniel appear to be a man of means?
No.
Absolutely not.
Let me ask you too about the type of cases that the Sheriff's Department and the County Attorney's Office prosecutes here at the border. Would that be a reason why officers and attorneys would be nervous about going to Mexico?
Objection leading and it exceeds the scope.
I'm on cross, Your Honor.
Well,
Exceeds the scope.
It's a direct question about the nervousness of people from the Sheriff's Department.
No arguing objection.
yeah, I think I'll allow it. Frankly, I think it's been asked and answered, but I think he's already answered it. But if there's
They got
something new to his
1 out
answer,
of
we'll
10
hear it.
objections they've won on the
Repeat the question.
prosecution side.
Yes, could you repeat it?
Sure. Would the type of cases that the Sheriff's Department and the County Attorney's Office both investigate and prosecute be a reason why agents and attorneys are nervous about going to Mexico?
Possibly.
Yeah, they
but I
don't want to be
know.
killed.
Thank you.
Any other questions from this witness, from any of the jurors? Thank you, sir. You could step down.
Actually, not just
Defense
that.
can call its next witness.
In reality,
Detective
they're
Raul
gonna call
Rodriguez?
Raul Rodriguez. Honestly, y'all, that he is so happy to be off that bench, off that stand. Honestly, guys, he knew it wasn't about being fearful of being harmed or anything. It was about having to get caught and deal with the Mexican police and them being held in jail. It was a real risky move. As far as, once again, I'm not a lawyer, but I did look it up, and it is against the law to do what he did. Unless there's some other statutes and limitations and things like that that I am not aware of. But I will soon because I'm going to school to be in criminal justice, and I don't know, I may go into law.
Thank you, sir. If you come over to the witness stand, please, and have a seat. Whenever you're ready, Ms.
All righty. Can you hear me okay?
Yes, ma'am.
Okay. Could you tell us your name and spell your last name for the record, please?
Raul, R-A-U-L, Rodriguez, R-O-D-R-I-G-U-E-Z.
And you are currently retired, is that right?
Yes.
What
Everybody's
what was your
retired.
employment prior to retirement?
Prior to my retirement, I was a lead investigator for the Santa Cruz County Attorney's Office.
Did you become involved in the case involving George Allen Kelly at some point?
Yes.
Could you just describe your initial involvement in that case?
My initial involvement is just to go over the reports, information that the Sheriff's Office investigators had done on that case and on with the witnesses.
And this is regarding an incident that took place on January 30th of 2023, right? That's the date of the incident,
I
right?
believe so, ma'am.
You weren't involved on January 30th, 2023, right?
No, ma'am.
So what did you review initially in this case?
Just initial reports as to the investigations that was being conducted by the Sheriff's Office criminal investigation.
Were you ultimately tasked with conducting an interview or assisting in an interview of a person named Daniel?
This is the guy that
Did
went
that
with
interview
him.
take place on or about February 23rd of 2023?
Yes.
Where did that interview take place?
At the Cassini Port of Entry.
Describe to me how that got arranged.
That was arranged by various telephone contacts with the victim to arrive at the Dean Casino port of entry, and with some logistics and phone calls with U.S. CBP personnel at the port.
And is it your understanding that the county attorney's office was able to communicate with the port authorities to allow Daniel to come there to meet with you folks?
That's correct.
Okay.
Yeah.
So that meeting didn't take place in Mexico, right?
No.
Okay. Tell me what you had reviewed or what your background information on the
Okay, I got to go back. I got to hear that again. Sorry. I got to hear it again.
you take place on or about February 23rd of 2023.
Yes.
Where did that interview take place?
At the Dean Casino port of entry.
Describe to me how that got arranged.
That was arranged by
Why did the sheriff go to Mexico then?
various telephone contacts with the victim to arrive at the Dean Casino port of entry, and with some logistics and phone calls with U.S. CBP personnel at the port.
And is it your understanding that the county attorney's office was able to communicate with the port authorities to allow Daniel to come there to meet with you folks?
That's correct.
So why
Okay.
did the sheriff?
So that meeting didn't take place in Mexico, right?
No.
Okay. Tell me what you had reviewed or what your background information on.
And those of you who are just joining me, this Daniel they're speaking of was one of the first witnesses and is a key witness in this case for the prosecution. And the sheriff was saying, and the gentleman that went with the sheriff was saying that they could not go and bring Daniel to the port of authorities or bring him into the United States, nor did they contact the Mexican police or the U.S. consulate in Mexico, because Daniel was not a Mexican citizen. He is a Honduran, and he is there illegally in Mexico, and he was terrified of losing terrified of being deported. But now you have Mr. Rodriguez, I think it is, who is sitting here and telling us that they met with Daniel in the port of entry. Sorry, not sorry. That doesn't make sense. I think that kind of just blew the sheriff out of the water on this issue.
The case was prior to interviewing Daniel on February 23rd.
And I'm not an attorney.
Background information was that the county, Santa Cruz County Sheriff's Office was conducting a criminal investigation into a homicide that occurred in Aquino Springs prior to that interview. Daniel was identified as a victim witness in that case. And arrangements were made to speak to Daniel at the port.
Were you aware before interviewing Daniel that any other people had come forward as witnesses in this case?
Yes.
How many other people?
I believe 2 other gentlemen were identified by the Santa Cruz County detective.
Okay. So in your review, you were aware of a person named Miguel who came forward, right?
Not too much. I didn't know a lot about his background, but I know the first name was Miguel.
Okay. And had you been able to review his statement prior to interviewing Daniel?
No, I did not.
Okay. And so you didn't know what he said prior
No,
to
I
interviewing
didn't.
him? What about a person named Ramon? Were you aware that a person named Ramon had come forward as well?
Yes.
And same question, had you been able to review Ramon's statement prior to interviewing Daniel?
No.
Okay, so you don't know the content of those
Sorry,
statements.
guys, my hair is getting all
Right.
caught up in my
Okay.
monitor cords.
Before interviewing Daniel, did you have any information involving the area where this incident was alleged to have taken place?
Yes.
What information did you have about the area?
That occurred in the vicinity of Aquino Springs at a ranch.
At a ranch. Were you familiar with the ranch at all?
Yes.
Once again, thank you for
How
joining.
so?
Like and subscribe and share.
Prior to my employment with
I
the
don't understand.
I'm trying to turn it off, Judge. I don't know why it's doing this. I'll be right back.
What?
There was a pinging noise.
Turn it off, Judge.
Were you familiar with the ranch at all?
Oh,
Yes.
she had technical
How so?
difficulties with her iPad.
Prior to my employment with the,
I'm trying to turn it off, Judge. I don't know why it's doing this. I'll be right back.
And that's appropriate, I think.
There was a pinging noise.
I don't understand either.
Well, she didn't want to disrupt the court, so she excused
Okay.
Go there,
herself
I can't even
appropriately.
make a phone call on that.
I
All right.
I
Sorry
can
about
appreciate that.
That's okay. Tell me how you were familiar with the
Or she's
ranch
using that as an
property.
excuse to get out of there and collect
prior to
information.
my employment with the Santa Cruz County Attorney's Office, I was a lieutenant with the Santa Cruz County Sheriff's Office. And that was my area of responsibility jurisdiction through my career was the Sheriff's Office.
Keno Springs area
Yes,
in general and out Duquesne Road, that area?
yes.
Okay. Did you know where Mr. Kelly's property was specifically, or did you just generally know the area?
Both,
Both. Okay. Had you ever been to Mr. Kelly's property?
yes.
When had you gone to Mr. Kelly's property?
That was numerous occasions over my career with the Sheriff's Office and maybe a drive-through at the inception of my career with the County Attorney's Office.
Okay. Had you seen Mr. Kelly's house?
Yes,
And so you knew where it was and you're familiar with what it looks like?
yes.
Okay. Were you provided any information in your review of these reports about where the body was located in relationship to the house?
No,
Okay, so that was not part of the background information that you had?
no,
Were you provided with any information regarding how the body was positioned when the body was discovered?
If I was brief on that, I don't recall that briefing.
Okay.
Why would you go interview?
Were
if
you
don't
aware
have
of
information?
where this property and where the house specifically is in location or in relationship to the border wall?
Yes,
And where is it in relationship to the border wall?
I couldn't tell you exactly. It's only approximately from the border.
Approximately how far
I would
away is
say,
it?
less than a mile.
Less than a mile, approximately?
Yeah.
And this is also obviously on the east side of Nogales, right?
That's correct.
Okay. So that's the information that you had when you go into this interview with Daniel, right?
That's correct.
And
Why?
when you interviewed Daniel, do you recall doing that interview?
I do.
And I'm just going to ask you about some of the statements that you made to Daniel in that interview, okay? Were you able to review a copy of the transcript of that interview prior to your testimony?
No.
If you need to refresh your recollection and you need to look at a transcript, just let me know, okay? And
I will.
I can put it up in front of you, all right?
I will.
Do you recall Daniel telling you in this interview that this took place west of Nogales?
Objection, Your Honor. Improper impeachment. I have the transcript.
And it's not for impeachment purposes, Your Honor. It's to show how this detective responded, given his knowledge of the case, to that statement.
What was that exact question again? Did
Did he recall Daniel telling him in the interview that this took place west of Nogales?
All right, overruled. You can answer.
And Your Honor, if I may, we can talk on the headset about this.
All right.
Okay, I noticed my image was a little fuzzy, and I noticed my camera was on manual focus and not autofocus. So let's see if that fixed it. Wow, guys, I think it did. Yay! I thought maybe either that or my eyes were going bad. I got faith on my shirt, but I'm cold in this office. So, wow. So they were able to interview Daniel at the Port of Authorities. So why did the sheriff have to go to Mexico? I am still on the boat of perplexion. I do not know. This is going to be hard for me to let it go. Let it go. This is driving me crazy. I know I'm all over the place, y'all guys. I'm tired. I streamed this morning. I'm streaming tonight. It's been a lot of streaming. Wow, I forgot to put the camera back, the monitor back. That makes sense. Oh, there. I see myself. Woohoo. Mary, thank you so much. Thanks, babe. Will do. You are an awesome friend. I appreciate everything you do. And I bless you. And you have sweet sleep tonight. Bye, beloved. Love you too. What time will you be in the morning?
Objection's overruled. You can ask the question again so it's fresh in the witness's mind.
So during this interview on February 23rd, do you recall asking Daniel where this took place? And do you recall him stating west of Nogales?
I have to see the transcript.
All right. Can you put this in front of the witness? Let me see if I can jump to the right page. Okay, so I'm on page 18.
Okay, let me have.
There's the bottom. So if it goes bottom of 18 over to the top of 19.
And again, ladies and gentlemen of the jury, this is being used to refresh the witness's recollection. It's not admitted into evidence, so that's why it's not on your screen.
Can you repeat the question, please?
Let me find it real quick. I think I'm on the wrong page. I'm on the wrong page. There we go. Okay. So the question is, you asked the witness, where did this take place? And he said west. Is that right? I'm looking at line 5, 6 right there.
Yes.
Okay. So he told you this took place west of Nogales. And can you take a look at line 7 for me? 7, 8.
Yes.
And that's you translating the witness's statement. Is that right?
Yes.
And you translated that as east. Is that right?
Sorry about that. I was on block. You mean to sit here and tell me that you did not have a professional, certified English to Spanish translator I don't care if you know Spanish. This is court. This is testifying. This is an interview. This is legal matter. You need to have a certified in Spanish interpreter like you have, translator like you have in court today. Oh, y'all, I'm an ASL interpreter. I know the law on this. Well, I'm not as English to Spanish, but it's my understanding he can't interpret. It doesn't matter if you speak Spanish. You can't interpret. You are involved in the conversation, and this is stuff that's going to be brought into legal matter.
Yes.
Even though you confirmed in Spanish, oeste, so you repeated that to him in Spanish,
Yes.
but then you translated that as east.
Yes.
Why did you do
I
that?
stop you. I just want to get an official, I think everyone probably, most everyone knows what that means, but, so the word in the transcript that the witness said was oeste, correct?
Yes.
All right. Can we ask the court interpreter to translate oeste?
Thank you, Your Honor.
Translate the word oeste. West. All right. What's the word for east? All right. Thank you. Apologies. You can go ahead.
Perfect. That is exactly what
So
you're supposed to do.
you incorrectly stated
That's
what
why
this
you have
witness
someone
had
who is
said.
certified and not
Why did you do that?
Oh.
I couldn't give you explanation of that.
You don't know?
No.
Is it possible that it had to do with the fact that you were familiar with this area and you knew that the area in question was to the east of Nogales?
And that's fair.
Possibly.
That is fair.
And then you ask the witness another question. I'm going to jump to page 41. Give me one moment.
But that's why you have a professional translator or certified or whatever the
Find
law
the line.
requires. When you interview anybody of
Oh,
a
this
different
is
language
off.
other than English within the United States or interviewing them for a case involving somebody within the United States. I'm going to harp on that. And you may not like it, but that's okay. It's my channel. That's one of my pet peeves. They don't even get proper interpreters.
Give me one moment, Judge. I think it's taking me to the wrong page.
See, you have to be a court certified ASL interpreter, whether it's a traffic ticket all the way up to federal court, in order to interpret in a courtroom where a judge is present. A basic interpreter can't do that. And you can't go and have a ticket and show
Okay.
up to court and
So
be
I'm
deaf
looking
and
at page
pull in a
40.
coworker that you
You were
have
asking the witness
taught
some questions
minimal
about
time
distance.
to interpret for you,
And
and they accept.
do you agree that you're telling the witness the distance? I'm looking at line 14 to line 15.
She's on
That's
15.
something that you're telling the witness, right?
I'm just affirming his recollection.
I love.
Well, you're saying, could it be the distance? Could it be more? Because 7
Objection,
meters.
Your Honor. Improper impeachment again.
I'm asking about this witness's statements, not about Daniel's statements.
Right. Well, objection's overruled, but ask the question first. What did the witness tell you? Or did the witness tell you this, this, and this? And what did you tell him? Just ask for his recollection first. And then if necessary, you can try to refresh his recollection with the transcript.
Thank you, Your Honor.
Do you recall telling Daniel at some point in the interview that he could possibly
But you
be
should not
wrong
have to
about
talk about
distance
that.
because the distance he was giving you was not very much?
I wasn't telling, I was asking, could it be the distance? Could it be more? It was a
Why were you
question,
asking him that?
Open-ended question as to his recollection.
Well, he had previously given you a statement about a distance, right?
He said 2 football fields.
Do you want me to scroll up so you can see that?
Football
Yes.
fields to the border from this man's home. Not 2 football fields.
So do you see around line 10 to 13, just if you could read that for yourself so you can refresh your recollection about the conversation?
Yes.
So the conversation in general, and I don't want to get into what the witness actually told you, but you're in general talking about a distance in this case, right?
That's correct.
And you're talking about a distance from the border wall, right?
That's correct.
He gave you a distance, right?
That's correct.
And then later you tell him, are you sure it was that close? Could it have been more? Something like that, right?
That's correct.
Why did you do that?
Because sometimes victims' recollections are different days, weeks afterwards, just to affirm his statement as to distance.
Well, when you say, are you sure it was that close? Do you believe that's suggestive to the witness?
I believe it's
Yes.
I was trying to elicit his detailed response to my question.
Well, he had previously given you a detailed response about a distance from where he was to the border wall, right?
That's correct.
But you didn't accept that. You asked him, are you sure it was that close?
It's a term of interview with the victims to reaffirm their statements.
Don't you believe that that's a little bit suggestive when you say, are you sure it was that close?
Yes.
Well, the question is subjective as to the response, and so I would say it's just my interview with the victim.
Well, let me ask you this. He gives you this distance away from the border wall that this happened. When you heard that, based on your knowledge of the area, and you know the ranch, you know where it is in relationship to the border wall, based on his statement, did you believe that that statement made sense with the knowledge that you had of the area?
No.
To the victim, it made sense.
No.
But to you, did it make sense?
No.
Okay,
No.
because you know the area, right?
Yes.
And the distance he was giving you was way too close to the border wall to make sense.
That's correct.
And so you said, are you sure you were that close? Or words to that effect, right?
That's correct.
Okay. My pages are off, so give me a moment. I hope I can find this one. Do you at some point, you talked to him about a distance that a person, specifically the shooter, was when the shooter was shooting at him, right? Do you recall having a conversation with him about that?
Yes, ma'am.
And he gave you another distance in that instance, right?
Yes, ma'am.
I believe so.
Then, do you recall asking him or doing something similar with that distance, saying, are you sure you were that close? That's really close. Do you recall a conversation to that effect?
Mm-hmm.
That's correct.
And was that sort of the same scenario? He's giving you a distance that doesn't make sense based on what you understand, and so you're asking him if he's really sure about that.
That's correct.
Fair enough? Okay. Do you remember at some point during this interview taking him outside to measure some distances?
That's correct.
Why did you do that?
Just to have the knowledge of his perception of distance.
And how was his perception of distance?
I believe it wasn't accurate.
It was or was not accurate?
It was not accurate.
Okay. And why did you believe that?
I have to stop. This guy works as a builder, carpenter, and a masonry. Does masonry work. He knows what a yard is. He played football, soccer. He knows the length of a football field. He watches American football. He knows the length of a football field.
He was just nervous. I don't know. I think it was just his demeanor as to his exposure to the interview itself.
I'm asking you, what about his perception of distance do you believe was not accurate? Let me back up a little bit. You take him outside to actually measure
You're
something.
not answering the question.
Do you recall that?
I just asked him, what do you believe this distance is?
And did you measure that to see if he was accurate?
It was approximate. I didn't measure it.
What was the distance that you asked him to estimate for you?
I couldn't recall
Okay.
Oh, come
Do you know how far
on.
off he was?
He was not accurate.
How so?
You're not helping the matters any.
Just by him, his response to my questions as to what's 15 meters.
Well, that was a distance you asked him about where he was in relation to the border wall when the shooting happened, right?
No,
That-
that was 15 meters that you have right here. Okay, before me.
Okay, so I just want to talk about when you take him outside to determine if he's accurate with distance. How did you do that?
I'd asked him how much is 10 meters.
And what did he do?
He pointed out to a wall and he said that was about 8 meters.
Okay, and did you measure that distance to see if he was accurate?
No,
So how do you know that he's not good with distances?
because the interpretation of my 8 meters were not the same as his 10.
I'm just trying to figure
Are
out what
you
you did.
accurate?
So during this interview, he's making some statements about distance that don't make sense based on what you know about the facts of the case, right?
That's correct.
And so you take him outside of the interview to try to come to some determination about how good he is with distances.
That's correct.
If I were to do that, I might look at the distance from here to the bench and I might say, how much would you estimate that to be? And I would get an estimate and then I would go measure it to see how close he was. Did you do anything like that?
No, ma'am.
No, I could not because we were at the port of entry at our office and it was busy. So it was just approximate.
What did you do?
I just, like I said, it was from the outside of that little office that we were in to a wall that's
You
within
did
the
nothing.
building that we were.
Okay, so you
making
had
the
him
interview.
estimate some distance.
Yes,
Do you recall what his estimate was?
I don't recall.
Do you recall what your estimate was of that distance?
I don't recall.
Do you recall how far off those two estimates
They
were?
were not the same.
How far off were they? 1 meter, 2 meters? How far off?
I since I didn't, repeat the question to him or I did it, I just assumed that my interpretation as to what was 5 meters or 10 meters was not the same with it.
Let's see.
Well,
if his
so how do
memory-
you know he's off?
Let's see if his memory improves when the prosecution talks to him.
If you don't know how far off he
Because
was?
he couldn't give me a distance that was accurate.
You didn't answer it the way you
I
wanted
didn't
him
try
to.
to
You didn't
pursue
measure to
that
see if you were right or he was right.
When you're saying he couldn't give you a distance that was accurate, you mean when you take him outside and have him estimate?
Your Honor, asked and answered.
No, he hasn't answered, so overruled.
The distance that we're talking about that he gave you that was not accurate, you're saying it was from a point that he estimated,
Yes,
but you don't know what that estimation was.
no,
How do you know it's not accurate?
just my interpretation of that distance that we were.
There you go. Your
How
interpretation-
different was your interpretation from his?
I would say less than a meter,
Okay, so you and he were pretty close.
but not accurate.
The prosecutor is so
So-
irritated with this questioning.
He's giving you a distance, 15 meters, let's say. He's not going to make an error like 15 meters is really a mile and a half. He's not that far off, is he?
No.
Yes,
Yes, he is that far off.
A
15
meter is a
meters
little
to
over
a mile and a half
3
is
feet.
not the same.
Right. My question is, Daniel, even if he's not perfectly accurate with his estimation of distances, he's not that far off based on what you observed in this interview, right?
You would have to ask Daniel.
Do you recall at one point in this interview saying that you need to take a time out? Do you recall saying that in this interview?
I don't remember.
Do you need to refresh your recollection? My
Yes.
page numbers, I wrote the citations down. For some reason, they're off. So let me see if I can find it.
Y'all, I'm a little chilly tonight, so I have this little, I love this. It feels like a hoodie, but it's
Council, let's just
heavy
jump on
and
the
very
headset for scheduling purposes.
luxurious feeling, but it's not the hoodie. Okay, we're going back to the. No, we don't have any sound. Okay, the reason why I'm irritated with this guy is because he has selective memory. He knows the measurements. He knows how far. He knows all this. I don't get it. I questioned when they talked about the measurements earlier in the case, day one, when the witness was on the stand, and they asked him, how far was it from where you were standing to the
All
border?
right, we're going to take our 30-minute mid-morning recess. It's
The links.
9:45. We'll be back here. Please be in the jury room at 10:15. We'll continue with the examination of this witness. We're in recess for 30 minutes.
Okay, so the whole gist of this thing is that the witness that this guy interviewed at the Port of Authorities, after he was interviewed by the sheriff department, the sheriff at the time in Mexico, was struggling with distance. If you were there, this guy is in the construction. He does masonry work. He makes rock fences. He knows his measurements. At least he knows what a yard is. He knows what a football field length is. And he can sit there and look and see between here and there is more than 2 football fields. And he said the wrong side of the ranch was on the wrong side of a city. He is.
Please be seated. The records show the presence of all the jurors, counsel, and the defendant.
This
Witness is retaking the witness stand.
I don't believe he was there before he shot him, and he's fabricating the whole testimony.
As soon as he's ready and you're ready, you can continue with your direct examination.
By the way, this young lady is very good, but I absolutely love the lead
Can you
attorney.
still hear me okay?
Yes.
Okay.
But this lady's
Just going back to this interview, and I think we got the right pages figured out now. But do you recall at some point in this interview saying, hang on, timeout? Do you recall that?
Yes.
Somebody
And
said a buzzing
why did
telephone
you
at
say
an interview.
timeout in this interview?
Oh, it was her.
Just to take a break.
Did you, after you said timeout, and I'm looking at page 43 there, line 19 and down, you said timeout, knowing the logistics, he might be confused. And because he was running away from Border Patrol, his logistics, where he was, because he doesn't know where he's at. You recall making that statement?
Yes.
So you're providing an explanation for something that this witness is telling you, right?
Sorry, guys.
Interpretation.
So why do you provide that interpretation?
Good question.
Because I believe he was confused.
Why did you believe he was confused?
If he's confused, you let him stay that way. It's
His
not for
statement
you to
didn't
fix
make
it.
sense. Is that what you're saying?
Parts of it.
And so you were trying to provide an explanation for why it's not making sense.
I was
And that
just
is
trying
not your
to
job.
get his information, not interpretation.
Well, and you say that his logistics weren't making sense, right?
Yes.
And they weren't making sense, what he was saying, right?
As to
What wasn't making sense about what he was saying?
just the distance.
Meaning what?
I don't believe they were accurate.
Okay. So they weren't accurate based on your knowledge of the area. Is that right?
Based on my experience.
Okay.
But you can't fix it.
Did you say at some point that maybe his locations were not defined as you might think? I'm looking at the page that's in front of you, line 5. If you just go ahead and read that to refresh your recollection.
Y'all, when you're interpreting anything, if the person says it, that's where it is.
And so you're telling
you're
him, or are you
interviewing-
telling him that
And when you interview somebody, and if they said they ran east, and you know that the direction of the body was on the west, and they were running west to east, that's what they said. And well, let me back up. If you ask them where the body was facing and they said west and you knew it was facing east, You keep your mouth shut. That's what they say. That's what you document. You don't interpret it. You don't fix it. You don't do any of that because that is not your job. Your job is to ask the question and get it answered and move on. If it's wrong, if it's confusing, if it is inaccurate, that's what it is. It's not your job to correct this guy's interview questions to what you think or believe is the right answer. Everybody in this department needs to go back to school. 101 interview procedures. I tell you what, after watching this case, I think I've made the right decision and to go into criminal justice in the fall.
Or you're saying that his locations might not be as defined as you might think?
You leave it alone. He's wrong, he's wrong.
That's not what it says.
I'm looking at line 5 to 7.
Okay, 7 does say.
Okay. So, and this is a sidebar you're having with the prosecutor in this interview, right? You're not telling this to Daniel.
I believe so.
Okay. And then do you later you explain something to Daniel about what you're telling the prosecutor in this interview? And I'm looking at line 11 through 12. Do you recall that?
Good impeachment, I think.
I'm going to scroll up for you, okay?
If you're watching, thank you so much for watching. I am streaming live on both YouTube
Yes.
and Facebook. Please comment. Like,
And
share,
you're
subscribe. It
telling
means the
him
world to me.
that he wasn't paying attention when he
I
was
really
fleeing.
appreciate you.
I'm asking.
You're asking him if he was paying attention when he was fleeing?
Yes.
In what direction was he running?
Is that what he said? Did he acknowledge that? Did he say, that's right, I wasn't paying attention? Do you recall?
I don't see it on this page.
Okay. I'm just asking if you recall. Do you remember him saying that?
Can you repeat the question, please?
Do you remember him agreeing with you and saying, yes, that's right, I wasn't paying attention because I was fleeing or something like that?
I can tell you the prosecution's not
Not really.
liking her line of questioning.
Do you recall at some point telling the prosecutor in this interview that Daniel's thought pattern is not like ours?
What?
Do you want me to pull up that page?
What is he? I can't say that.
It even highlighted it for some reason. Okay, so just take a look at that and refresh your recollection.
Breaking news.
He's human.
Yes.
Okay, why did you tell the prosecutor that his thought pattern is not like ours? What did you mean by that?
As to our interview and his statement,
Meaning
wanna see
what?
you get out of
Tell me
this.
what that means.
he
We
couldn't
are-
explain what occurred.
Why do you think he couldn't explain what occurred?
Because he wasn't there.
in detail what his statement was as to what occurred.
Or
When
he
you
was
say in
making it up and
detail,
he
what
was
do
the
you mean?
shooter.
He was very brief. He was very nervous.
Because he's lying.
Took a while to get him to
Sorry, I'm sarcastic. It's late.
be comfortable with the interview.
I want another.
Well, so he did provide some details to you. For example,
21
that
minutes before I
15-meter
them
distance.
for 2
That
hours.
was a detail he
21.
provided to you, right?
Yes.
So it was detailed. It was just not correct. Is that right?
No.
He says this happened 15 meters away from the border wall, right? That's a detail he provided, right?
Yes.
And that detail
15 meters is
is
like
just not correct.
It's not correct.
It's not that it's not detailed. It's not correct.
a mile and a half.
Did that ever concern you? So you have this whole interview. You provide him with some explanations. You're saying his thought pattern's not like ours. You take him outside to try to get him to narrow in his distance or to try to judge how good he is with distance. Did it ever concern you that what he said just didn't make sense?
That's
No.
Why didn't that concern
15
you?
yards.
Because he was a victim of a crime, and it was probably hard for him to interpret.
How do you know he was a victim of a crime?
Because I was briefed on this case, and he was identified as the victim.
By who?
Did he say he was a victim, or did you identify him as a victim?
How do
He
you know
could have
he was
been
a
the
victim of a
shooter
crime?
for all we know.
Because he was mentioned as a victim of this crime.
Who
before.
mentioned him as the victim?
If
Before
if I remember correctly, I read the reports.
Who wrote
Somebody
the
can make a
report?
false report to law enforcement and claim to be a victim of a crime. That's possible, right?
Yes.
And before you had this interview with
And he could have
Daniel,
been the
you were
shooter.
aware of two other potential witnesses who had come forward. We've talked about that already, right? Miguel and Ramon, right?
And
That's
they
correct.
disappeared.
Daniel doesn't ever mention Miguel and Ramon to you,
Correct.
right? Or he says, let me rephrase that. Based on what you hear from him, your understanding is Daniel's the only one present when this shooting takes place, right?
Yes.
No.
Who else, besides Gabriel? Daniel and Gabriel.
Objection, Your Honor. I'm having a hard time figuring out how this isn't improper impeachment again, and what the purpose of this line of questioning is.
And Your Honor, the purpose of the line of questioning is to explore how the detective treats a witness statement. He provides explanations and he provides reasons and he tells the witness the reasons why the witness is being incorrect instead of pursuing this witness as a potential suspect or as a potential person who's making a false report. So it's
Objections.
about, thank you.
And Your Honor, the state's position is that this is just an end run around letting Daniel explain the statement. They didn't confront him with the statement, and this is just an end run around that.
Objections overruled.
Thank you.
Oh, the defense has lost.
So,
I would say 85.
When you interviewed Daniel, was it your understanding from him that he and Gabriel are the only two people present when this shooting takes place?
Not that I recall.
You don't remember if he said there were other people there or other witnesses? You don't remember?
He did mention there was other witnesses, but the way you presented the question is that there was never anybody other than them present.
Other than who?
Daniel and the victim.
You're saying that Daniel somehow told you that there were other witnesses present during the shooting besides him and Gabriel.
Based on his statement that when he crossed with a group of people.
I'm talking about when the shooting happens, not when he crosses.
Quit playing word games. You don't want to answer this. Evasive.
I don't recall if he mentioned
Oh,
anything
that's simple. I don't recall. Get you out of it.
at the shooting.
You don't recall. Okay.
No.
If he were to tell you he's the only witness to this event, but you know that there are two other statements out there, does that concern you?
Yes,
Yes.
Why does that concern you?
because there's other witnesses.
And those statements are not consistent.
I don't know the other statement from the other witness.
If the statements are inconsistent, that's a concern,
If
right?
the statements are,
And why is that a concern?
it's something for the court to address.
What about you as a detective? Is it a concern as a detective when multiple people have different statements about an event?
Yes,
Why is it a concern to you as a detective?
because you want to elicit the truth.
And if multiple statements are inconsistent with one another, does that mean one or more of those statements might not be true?
So why did you not investigate all three statements? Why did you not investigate all three of those potential
Can you repeat the
witnesses and
question?
see if they were
If multiple statements are
Control.
inconsistent with one another,
um,
does that mean that one or
Rules.
more of those statements might not be true?
That's possible.
What do you do to test a person's credibility? Let's say you're concerned. Let's say someone comes forward with statements and those statements do not make sense according to the facts that you know about the case. What do you do to test that person's credibility?
There's various things that that you could do by,
What are some of those things?
you know, what is his background? How long did he go to school? If he can properly describe something to me during a interview. There's a lot of factors that come in.
Interviewed them multiple times and see
So,
if their story
If
stick.
he can properly describe something to you, what do you mean when you say that?
Exactly what you're asking me to do with you is that if you you ask a question, then I give you an answer to that question.
I think this was a witch hunt.
So let's say, for example, I'm in the interview. I know this happened east of Nogales. I ask this person, where did this happen? He says west. Could you possibly bring out a map and say, can you show me where this happened?
Yes,
That'd be one way to maybe test the person's credibility, right?
that's correct.
Did you do that with this witness?
Nope.
Why not?
I didn't have a map.
Could you go
Pull
on
it up on
Google
the
Earth
phone.
and get one?
Not at the border.
You got a
Did you
phone
do
that
any
you pull up Google
follow-up?
map?
With this problem, this west versus east problem? Did you follow
No,
up with this witness?
I did not.
Why not?
I wasn't tasked to do the follow-up on this interview.
Y'all.
If a witness says, for example, somebody else was there was another person who was a member of the group, and if you know who an alleged other member of the group is, could you do a photo lineup to see if the witness could identify that person?
Yes,
That'd be another way to test this person's credibility, right?
92% cocoa,
Did you do that?
intense
No.
dark.
Did you try to have the witness do a photo identification of Mr. Kelly at any point?
no,
Why not?
I wasn't tasked to do that.
Do you know if anyone was ever tasked with doing that?
If you're
No.
doing the interview, you're tasked to do it.
These multiple, I guess, these areas of concern. So you're talking to this witness, and what he's saying doesn't make sense. He's talking about distances to the border wall that don't make sense. He's talking about locations that are on the other side of town that don't make sense. When you provided him and the prosecutor in this interview with explanations, why did you do that instead of testing his credibility?
It was based on just the interaction I had with the victim at that point. I didn't think it was needed at that point.
And that's because you just assumed he was a victim?
Based on his statement.
Mm-mm. Whoa, whoa,
I don't have
whoa,
anything else,
whoa,
Your
whoa.
Okay. Thank you. Cross-examination from the state.
Thank you, Your Honor. Detective, if the defense,
Whoa. You said that he was a victim based on what you had read in a report and was told. Now you say it's based on the fact that he told you he was?
if the victim, Daniel, had identified the defendant in court the following day after this interview, would it have been necessary to do a follow-up with a photo lineup?
Anybody sitting in that
No, it
defendant's
wouldn't
chair
be
is who he's going to
Do you know if that occurred?
You need a lineup.
If you know.
No, I don't know.
If I walk into court and they ask me to get on the stand and they ask me to identify the person who did this, and there's one person sitting in that defendant chair, I'm going to point to him. Please.
But if that occurred, you'd agree that wouldn't be
I'm about ready
necessary.
to go,
Objection
Karen.
asked and answered.
Sustain.
If your name is Karen.
Defense counsel asked you about some photo lineups. Do
Society.
you know if photo lineups were done to determine if some other individuals were with him that day? If you know.
I do not know.
You weren't tasked with doing one, but there were lots of other detectives on this case. Is that right?
That's correct.
But you're the one interviewing
So if they did a
him.
photo lineup, you don't know about it.
No, ma'am.
You're interviewing him. You should know. You should
You
know.
talked
everything
about the
that interview.
port and not having a map available. Do you recall why that was?
At the casino port of entry.
But you have a cell phone.
I didn't hear what you said.
He said at the deconceiving port of entry, second floor. Right. So we were at the deconceiving port of entry, second floor. Were there issues? Were there reasons why we weren't able to connect?
Yes, it's kind of at the border, it's a no man's land. Cell phone service is not available.
Kind of sketchy there? Cell phone service is kind of
It's
sketchy?
almost nil.
I want to go back to your
I have
interview.
crossed the border
with
9 to
Daniel.
10 times in that
Do you
area. He
re-
knows it well.
Recall Daniel
Wonderful.
describing other things about the location of where this incident occurred and where he was that day.
Yes,
Did Daniel describe for you crossing the border at the end of the border wall?
yes,
Did he describe for you going to an area he called Washington?
yes,
Are you familiar with an area called Washington Camp?
yes.
Where is that in relation to the end of the border wall?
Approximately a mile and a half away.
And which
Parts
direction?
West.
Be due north.
So just north of the end of the border wall is the area called Washington Camp.
That's correct.
Kelly's
Did
Ranch
he
is
also talk to you about an area called Keno Springs during your interview?
Volcano Springs is
Yes.
the ranch.
And where is Keno Springs in relation to the end of the border wall?
Approximately 2 miles northwest of the border,
The end of the border wall.
the end of the border.
So,
So where-
and where is
Okay.
Keno?
You can't give a vague answer like that. You got to set ground base for the border wall. They got 320, 360 miles of border wall from the port of entry right here. God, I love sign language because we're very, very clear on perception. If you're standing here at the port of entry, the border wall goes like this. This is the end of the border wall. Where is the Washington? Where is, give us place because it depends on which direction and where you're standing. That's very
Keno
vague.
Springs and Washington Camp and the end of the border wall that are close to those in relation to Nogales.
It's east of Nogales.
So when Daniel told you he was at Washington Camp and Keno Springs and the end of the border wall, but that occurred west of Nogales, which thing did you think was correct?
You can't fix what he
That he
said.
was
If he
east.
said west, he said west. You can't fix it for him.
So when Daniel described Keno Springs, do you recall him describing the area at all?
Yes.
What do you remember him describing?
Descriptions of the row of houses.
Did he describe some pine trees in the area?
In the hills.
If you recall.
Yes.
As y'all can tell, Daniel, their key witness for the prosecution that testified first and second day of trial, was all over the page. And yes, I apologize, I'm tired. But I'm so happy to be with you. I'm so happy to get this today. I'm
Would
going to
it refresh your
standing.
recollection if I showed you the transcript?
Yes.
I think
Showing
that's
the
what a jury
witness
tomorrow.
what's been marked as State's Exhibit 18 on page 133. If you could take a look at
Which will make the judge happy. He wanted the
at the
jury to have
bottom
it
of
by
page
Thursday.
133 and the top
And they're over a week.
of page 1.
They're a week
34.
over schedule.
Let me know when you want me to advance it.
I am skimming ahead, y'all.
Yes.
And
Okay.
can you tell me what Daniel said about the houses with the pine trees?
That it was close where Gabriel died, or it was farther than, from Gabriel. That was line 9. And then You're on 135 now.
Yes. So what was the eventual answer about where the house with the pine trees were? After you were able to explain to him what your question was?
The house was farther away as in reference to the pine trees.
Okay. So the house with the pine trees was farther away from where Gabriel died. Is that what the transcript says?
That's correct.
Tell me about what Daniel told you his educational experience was.
That he attended school up to 6th grade.
And what did he tell you he did for a living?
That he worked on farms
As a farmhand?
as a farmhand.
But that's not what he said when he testified. He said he did construction and masonry work, and sometimes farmhand.
Did you
Farmhand,
talk to Daniel
mostly construction and masonry work.
about the sequence of events and have concerns as you talk to him about his ability to do distances?
If you put fences together, you can handle yards.
Did he describe for you running from the Border Patrol in Washington camp to the Keno Springs area?
Yes.
And did he describe that he ran for about 30 minutes?
Yes.
And I want to go specifically to a page 31.
I'm skimming forward. He's going to read it.
Initially crossed the border wall.
Yes.
And when he talked to you about crossing the border wall, did you ask him where he went?
Yes.
And are you familiar with that area?
Yes.
And did he describe crossing the border wall and going up a hill?
That's correct.
And then did he describe that as 10 to 15 meters?
That's correct.
Was that accurate?
16.4 yards.
No.
And he said he was about halfway up the hillside. Is that right?
Think about
That's correct.
16.4 yards. That's not accurate. Even if his meters and yards and all, even if his measurements are off, take that out of the equation. His story is still so full of holes. I'm still wanting to know what happened to the 12 liters of water. He had.
Did he describe for
Victim had
you
6. They dropped them.
that there was
Where
a
are
horse between him and the shooter during your interview?
Yes.
There was no
And
horse
then
between
when you
them
spoke to him,
in the area.
he said that the shooter was 7 meters away. Is that right?
7 meters. It's about
Not on
7
this page, but on the
7
previous
yards.
one council showed you.
Yes.
Pretty close.
Would that make sense if the horse is between him and the shooter? That
Objection
it's only
argumentative.
7
Sustained.
meters?
Objection sustained.
Would it be possible for the horse to be between him and the shooter if it was only 7 meters?
Yeah.
It's possible.
It is possible?
It is possible.
Okay.
Yeah. It could be standing
Is
right
that
here next to me.
likely?
Yes.
It's likely that he's that close and there's a horse in between?
Objection asked and answered.
Sustained. That's his answer.
She didn't like that answer. Yeah, it could be between them, but the question is, would it be likely the horse would have been shot
And what did Daniel tell you about
if he was there?
how he was feeling at the time he got shot at?
If the horse was between
He was in
him
fear of his life.
and the
And
shooter?
before he got shot, did he tell you what his health was like at that point because of fleeing from the Border Patrol?
He was tired.
And did he indicate to you that he was sick?
Object, Judge. There needs to be a non-hearsay purpose for this.
Judge, the defense is challenging the witnesses' distances and whether this witness did something improper with.
What does that have to do with your
suggesting that the
improper
witnesses'
question?
distances were off? When in reality, there are a lot of reasons why this witness's distances were not appropriate. And that's what I'm eliciting.
He
The
did
witness
not-
was sick.
The witness did not bring up that he was sick prior to running. He brought up that he was sick from running in the and being fearful after the shot. He said he threw up at the wall. Well, the wall is 1.5 miles from where the guy was shot. If he's running like a banshee and he drank all, I don't know. I'm giving a hypothesis, but the point is that nowhere in testimony did he say, I have digestive issues or I have issues that cause me to not be able to give you accurate measurements. And digestive issues and running is not one of those, especially when you say you work in construction and in masonry work. You know, if they tell you I need a wall 50 meters long, you know what that is.
You're saying.
Let's do a brief bench conference.
I knew that was coming. I knew that was coming. At no time did this witness bring in anywhere in this trial, nor have I heard from anybody who interviewed him that this guy had any kind of health conditions. Sorry. She should have, upon cross-examination of the witness, brought this up herself. She can't ask this guy, the witness's health status. It's not documented. I've not heard or seen hide nor hair that this guy had abdominal cancer. God forbid anybody does, but he had no health issues that was brought up in trial. And now you're trying to use the fact that he was throwing up and not feeling well as a reason why he was scared and anxious as to why he couldn't tell you how far he was from the border. Now, he did come into court and he did say he had anxiety. And yes, anxiety can make you throw up. But this guy had been in and out of the U.S. 10 times. 10 times. I mean, caught 10 times. And even caught carrying drugs once. So please don't tell me. I mean, I know it's nerve-wracking and everything, but I would think that someone as experienced as he would not be in that state. Honestly, if you were a first-timer, you never done this before, and you saw a guy get shot, and you're running, I might be able to believe it. With this guy, I don't believe it. I'm sorry, that's my own humble opinion, and I'm not going to apologize anymore. My son said I say sorry too much. That's my humble opinion. I don't give this witness any credibility. I wish y'all, if y'all want to know, go back to day 1 and 2 and watch his testimony. No. I don't believe it. I really struggle with this guy because when you go to interview somebody on a murder, you don't go in there empty-handed. You get as much information that you can beforehand. And a lot of this information was available to him and he did not use it. Sorry, I've been off and on streams all day. The lack of preparation before they went to Mexico for these interviews, the lack of everything in this case. Like I said, I don't know how it got past a grand jury. I really don't. I came into this case not knowing a thing about it. Everything I've learned from trial, literally as an alternate juror. And I could not convict. I firmly believe that the victim, was either shot by the witness or shot by the group of people that, or cartel that will kill people and steal money and whatever drugs or anything that they may be carrying. I believe that the defense is correct that the shooter was in the wash or the gully, and that then the victim was standing or climbing out, trying to flee, and the gun shot happened, and that would give the appropriate trajectory of the bullet that went through his body. Very plausible explanation. Oh, Mary, you were so funny. Subpoena the horse. Oh my God, you were so funny. Only if we could. The horse was startled by the shot, Mr. Kelly, but the struggle for me in this whole case is that there's too many holes. I don't believe Mr. Kelly shot this guy. I know not everybody lives on a ranch. Not everybody understands the ranch mentality, the ranchman's mentality. My grandpa lived on the ranch. In fact, this guy reminds me a lot of my grandpa. And no, I'm not on his side because of that. But what I'm saying is I understand some of the behaviors, like keeping your rifle by the door that you enter. So if you come in, if you have a door on the west and a door on the east, front and back porch, and you enter the west door, you put the gun at the west door, you hang your coat up, whatever. And then you come in the east, you do it that. I mean,
The objection is sustained.
oh, yay. Yippee. The defense,
One more thing.
I mean, the
Let's go on this,
prosecution
though.
won it.
Sorry, I forgot.
Oh, no. We're doing this again. So my grandpa used to walk in, and whatever door he walked in, he laid his gun. Both doors were hangers, the little wood with the dowels coming out that he made. And he made them big because he always had a belt on waist when he was out on the ranch with a gun, and he had a rifle. He put his hat up, he put the coat up, or a little jacket if he had anything of the sorts. He'd hang the gun belt up, and he'd lean the rifle up on the wall by the door. Either door that he came in. And the prosecution tried to make it out like he's a vigilante because he had 2 guns on him. Y'all, they live on the border of Mexico and Arizona. I live in Central Texas, and I'm on my papa's ranch. I'm going to have a gun on hip, and I'm going to have a gun in hand. One of them's going to have snake shots in it. Because there's a lot of snakes. There's a lot of very dangerous coyotes. We have wild boar, which are very deadly. We actually wildcats. I can't believe recently we saw on a hunter's camera of a wildcat chasing deer and they're moving closer and closer to our population. This is typical ranchers mentality. and it's
Were
not
there
bad.
numerous times during this interview that it was very clear that Daniel's ability to judge distances was inaccurate?
That's correct.
Do you know anything about the other witnesses' statements that the defense asked you about, Ramon or Miguel?
No.
Were you tasked with assisting and tracking down Miguel and the number that was provided to 911?
Yes.
And what did you discover when you tried to call that number?
If I remember correctly, a person answered and didn't answer after I identified myself.
They hung up.
Yes.
And what about Ramon? Did you assist the sheriff's department in attempting to track down an individual named Ramon?
That's correct.
What did you do?
I believe Ramon was living in Nogales, Sonora. We called the number listed, and his mother answered.
When you interviewed Daniel, what was his demeanor like that day?
I'll be right back, y'all. I'm going to keep this going. I think I just said a whole bunch of stuff you didn't get.
Very nervous.
Get later.
Very almost sick to the point of doing the interview that he was not well.
What did you attribute that to?
He said that he was still suffering some mental issues because of the shooting.
Did he talk to you about nightmares?
Yes.
And did he talk to you about other physical ailments he was having as a result?
Yes, yes.
And what were the physical ailments he talked about?
Objection, hearsay.
That's all I had, Your Honor.
Redirect examination.
Thank you. Real quick, the state was asking you some questions about photo lineups and if you knew whether Daniel was ever presented with a photo lineup that included Ramon. And you said you didn't know about that, right?
That's correct.
If Daniel were provided with a photo lineup that included Ramon, and if Daniel was not able to identify Ramon, would that be an additional concern to you?
Again, Your Honor, this calls for speculation and foundation.
Overruled.
So you can answer.
Yes,
That would be an additional concern.
yes.
The state was asking you about some pine trees or some of Daniel's statements regarding pine trees. And can you put this up in front of the witness, Validia? I'm just going to show you this portion of the same transcript involving pine trees. You go ahead, read that, and let me know if I need to scroll.
Which line?
Go ahead and start at line 4 and go until line 17.
And out of fairness, for what purposes this statement of Daniel being offered?
Your Honor, it's again not offered for the truth of the matter asserted. It's clearly not true. The statement is
Okay, that's
saying.
fine. You've said enough. Thank you.
Okay.
All right.
Did you get a chance to read that?
Yes,
So Daniel, when he talks about pine trees, do you recall he's telling you he is near some pine trees that are right up against the little road that goes right along the edge of the wall.
Your Honor, just for the record, this is a different reference, so if we could have the page reference for the record. This is a different time in the transcript and a different reference.
Page 118. Do you see that where he's saying there are pine trees that are right up against the little road that goes right along the edge of the wall? Do you see that?
no, I don't see it.
Line 6, it says, like some pine trees that were right up against the little road that goes right along the edge. And then there's that goes, line 12, that goes along all of the edge of the wall. And I went running along that edge. And then I was looking. I looked, I saw that person.
He, on line 10, he says that he's going through where the wall is, and then he was running out to the edge. And that's when he saw that person. I don't see where he.
All right, let's publish this page to the jury. I think
Sure.
that I'm exercising discretion in this regard because I think it's relevant to the examination. Just this page.
Okay, fair enough. So Daniel is telling you that he sees some pine trees that are against the edge of the road that goes next to the wall. Is that fair to say?
On which line does that say?
Just one second, because for the jurors, this again is another demonstrative exhibit. This is just to try to aid with your understanding of this examination of this witness on this point of the testimony. This is not evidence itself, but it's just demonstrative, so you can understand what the questions are directed to.
Your Honor, can we go on the headset, please?
Yes.
No. No.
Okay, guys. They're fighting. There has been more objections today than the entire trial. This is battling it out at the end. I am not surprised, but yeah, a lot of objections. Yeah, I go from super cold to super hot in here. The lights, the computer, everything's heating up. I've got a YouTube camera, I've got a GoPro camera over there that I'm in the process of getting hooked up. I need to get a cable. I've got external mics. I look at this, y'all. Look how little they are. Whoop, whoop, external mics. So I can get this. I'll just clip these to me and see how the sound is. And then push this aside. I want to sign when I talk so I can share this with my deaf community. Right now, we have closed captioning for the deaf on this video, but when they're live, we do not. And when I speak, sometimes it's very hard because I'm not being very clear because I got the mic here, because my voice closed captioning and the video closed captioning overlap. And I want to be able to share with my deaf community my thoughts, my voice. It's not easy to talk and sign at the same time, but I've become better. No, just so you know, I have another shirt under. That's probably why I'm so hot, because I have another shirt. And this cable is driving me nuts. I need to get an extender. So, thank you guys so very much for sticking with me. It really blesses me when you do. I would just want to make some things available to you guys and share. One of the things is only me and one other person who are doing this live. It wasn't until
Go
the judge
ahead.
walked off the bench that anybody else was watching
So
it.
you see line 6, where Daniel says, I mentioned before, like some
Okay,
pine
one
trees
that
that
way.
were right up against the little road that goes right along the edge. And then I'm going to line 12, that goes along all of the edge of the wall. And I went running all along that edge. And then I was looking and I saw that person. So he's describing seeing pine trees on the edge of the border wall, correct?
I don't think there are pine trees along the border wall.
No, it's two different issues there. He's describing the pine trees where he was, and the mural is, if I look at it correctly, on line 10, he's saying that he's going through the edge of the mural.
What is that word?
He's running
and
along.
he's describing, if you don't mind,
At the wall?
he's describing when he's at the wall, when he was at first talking where the pine trees were.
So when he
jumps-
says,
He jumps his statement as to where he was.
so I understand that's your explanation. But what he
Yeah.
states is there are some pine trees that are right up against the little road that goes right along the edge of the wall. That's his statement,
Is that correct?
right? That's what he says,
Let's have
right?
let's have the certified court interpreter interpret those lines from from Spanish into English. All right.
Thank you.
So,
Get her on mic.
That would be line 1 through 3 and line 10 through 11.
right.
And again, it's a yes or no. It is not.
We got to make sure you record it,
Sorry.
and
the witness's interpretation, I forgot how to sign it. I think it's this or it's this. But that man who's testifying, that's not for him to interpret or translate. That is for the
10 and
Spanish
11,
translator.
correct. But we need to make sure you're projecting and you're recorded, so we need you to,
Get on the mic.
thank you.
Bueno. It was at the same time in the same area where I went up then when is it that I come out of the wash? I went up, there were some trees. What can I tell you, the last time when it was like pines that were next to the little highway that goes along the edge, where the wall is, and I went running by the edge, and then I was looking, and then when I looked, I was looking at the person.
Thank you. All right, you can resume the questioning.
Okay. Whoa, 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 whoa.
So
whoa,
he's
whoa,
describing.
Whoa. Whoa. The wall is 17 to 18 football fields minimum away, and that's a mile. The wall is a mile and a half away from the home of Mr. Kelly. So you're telling me through a very heavy wooded ranch in the middle of January where everything's all gray, a lot of overheard. I mean, it is dirt. There are patches, but it's like here in the Texas Hill Country in the winter. You cannot see through all of that a mile and a half of the way and see this guy standing over the body. You can't. If he's saying he's at the wall, there is no way humanly possible from the photos, from the drone, and everything they have shown. And that's why they took the jury to the wall so they could see how far it was from the house. I'm sorry. I call it. Call bull. Let's see what they
Describing running away from this shooting.
Thank you for joining me.
Looking back when he's at the end of the wall and seeing the person, right?
Yes.
And you know, based on your familiarity with the area and based on where that property is, that that's not possible, right?
God, I like it when I'm right.
It's
By the
just,
way,
it's not possible to be at the end of the wall and look back and see Mr. Kelly's property, right?
I wasn't there, ma'am.
Oh, but you just said you knew the
Okay.
area very well.
Did you have concerns about that when you got this statement?
Do we want to ask the court reporter to read back what you said? Because you said earlier you knew that area very, very well. You knew it. And you were able to describe everything. So being evasive, are we not? Sorry,
Not
guys,
at that
I'm getting excited.
Why not?
Because we were conducting the interview.
Well, if a witness says something that's obviously impossible based on what you know about the evidence, that causes concern, right?
Yes.
But you
And
have
he's
a problem
not just,
his answers.
making errors in distance. He's placing himself in a physical spot that he knows, the end of the wall, right? The road that goes along the end of the wall.
Yes.
That's not a mistake that you make because you have a 6th grade education, right?
Correct.
If I say I'm at the end of the wall, but really I'm up on a mountain somewhere, that's a big problem, right?
Yes.
That's not
So
basic education.
when you see this statement, you're not concerned that this person might be making a false report?
Hello?
And that's why the interview continues.
Or maybe this person wasn't there. Is that possible?
But he's somehow your star
I believe
witness?
he was there.
Even though he's making these impossible statements?
That's why we were having the interview.
Did it ever occur to you that maybe he wasn't there?
Yes,
Why did that occur to you?
Sir,
for the same reasons that you're giving me.
you're sounding
And what did you do to explore that possibility?
We continue to
idiot.
interview.
And during this interview, you came to the conclusion that he really was there,
That's correct.
even though he says, I'm at the end of the wall when I look back and I see the shooter. And even though he says, I'm 15 meters away from the border wall when this shooting happens, you still think he was really there?
You couldn't articulate that point of view.
Yeah.
Well, he articulated 15 meters pretty well, right?
Yes, he did.
And he articulated the end of the wall pretty well, right?
Yes, he did.
He even mentioned the pine trees. So he's adding detail, right?
Exactly.
And yet you still think that he was there.
Correct.
Even when he says the shooter was 7 meters away from me, you still think he was there.
And the horse was between us
I believe so.
and never was hit. Get another
You said that he provided there were numerous times in this interview that you were concerned about his
Yes, I am.
ability to determine distance, right? That's what you told the prosecutor, right?
That's correct.
But that's not because when you actually measured distance, he was very far off.
That's correct.
That's just because he's telling you things that you know are wrong based on the scene, correct?
Correct.
I would, if I was your boss, I'm going to pause it right here. I'd be saying, sir, you need to find another job. For those of you who are just joining, thank you very much. If you don't know what's happening on this case, this guy is testifying about a witness that he interviewed that is a Honduras national that's living into Mexico illegally, that was coming in and out of the United States. He got caught 10 times, once with drugs, and served time. He says this guy, Daniel, is saying that he's a witness to the shooting, but yet everything he's giving him is wrong. The body of the victim was found 115 yards from the house. Mr. Kelly, who's the gentleman in the blue shirt at the defense table with the beige vest, was standing on his patio 115 yards away and shot a gun up in the air. Hours and hours later, later that afternoon, early evening, this body was found by his dogs. Problem is the bullet comes in the lower part of the ribs and out by the sternum. There's so much wrong with this. And this guy's sitting here telling us, and if this is a representation of the sheriffs and the border patrol that we have, and no wonder we have problems, because this guy is clearly not telling the truth. If you go back and watch the witnesses' testimony, Daniel, that they're speaking of, that was on the first and second day of this trial, which is on my YouTube and Facebook page, you will see all the inconsistencies. He said, I am a carpenter and I do masonry work as well. And sometimes when I need to, I do farm work. There is just so much inconsistency. If you are a carpenter or a masonry and you got a job and you're hired by a rancher and the rancher says, I want a fence 80 meters long, and in between at the 40 meter, I want a gate. This guy knows his meters. He was able to say that he understood what a length of an American football field was. And this guy here is sitting here saying that he believes this guy is a real witness when he says that Mr. Kelly shot the victim while this guy, Daniel, was standing directly behind the victim at 16 yards. Less than 16 meters. That's about 16 yards or 7 yards or whatever. But here's my question I wanted to ask Mr. Daniel. This was a through and through shot. Where was the bullet? Did it whiz by you, or why were you not hit? There is just so many inconsistencies, y'all.
I don't have anything else, Your Honor.
And another limiting instruction, I should have given it when you saw this page of the transcript. Statements of Daniel that are being offered by the defense are not being offered for the truth of the matter asserted. They're being offered for the opposite purpose. So therefore, as I've defined hearsay for you before, it's not hearsay because it's not offered for the truth of what Daniel said. It's offered to show that it's the opposite, not true. All right.
So
Uh,
they're
Based on
impeaching
counsel's
Daniel,
argument, I want to
and they're
I want to
impeaching this
again make the
witness.
argument with respect to this transcript. And if the court wants to do that on the headset, I'm happy to do that. But based on the continuing questioning,
All right.
I need to make a record.
First, any questions for this witness from the jurors?
So Mr. Rodriguez was just
All
impeached
right,
and
seeing
so
none,
was
you can still think
Daniel.
about, we'll go on the transcript. Excuse me, we'll go on the headset briefly.
Y'all, comment if you agree with me. Y'all are watching. Please comment. Let me know. Like, subscribe, guys, please. This is new to me. I'm trying to build my channel. In the near future, everything I say will be signed. I've just got to connect my microphone that I can clip on and sign because this beast is difficult to do that. There's so much wrong there. And Mr. Rodriguez is interviewing this witness without having all the facts. Uh-oh, they're coming to get Miss Kelly. I got to hand it to the court bailiff.
back on-
They're awesome.
All right. You all right?
I don't know what they said to Miss... Oh, maybe
something
Miss
else?
Kelly was doing
I'm
something wrong, or the lady with. Oh, we
Hold
got to
on.
go back. The other day, they had a guy sitting right here where the tissue box is on the plaintiff's side taking pictures with his phone of all the evidence on the computer, which I thought I couldn't believe the judge didn't nail his hiney to the wall for that. But Mr. Kelly, the other part of the problem is the telephone game. You know, we all know the telephone game. And a lot of the reasons why Mr. Kelly was arrested was because Mr. Kelly reported to the ranch liaison, who was a Border Patrol agent who just so happened to be off that day. But he contacted his supervisor. His supervisor contacted their supervisor. That's 3. Then their supervisor contacted the sheriff's office in 911. Mr. Kelly was told not to contact sheriff office if anything had to involve illegals. And so I know, right, Mary? The horse can identify the shooter. I wish the horse could talk. I'm sure he could identify the shooter. It is not uncommon for what Mr. Kelly did. I feel sorry for him at this point. I really went into this non-biased. I went into this thinking he very well could have done it. The bullet could have gone up and come down and hit the guy. I had no knowledge of this. I am hearing this as an alternate juror. And so I really am just forming my opinions based on the testimony and the videos that I have put on. And I have to tell you, if I had to go to...
All right, we're back on the record before the jury.
I could not.
No questions for this witness, ladies and gentlemen of the jury?
It's going to be a real
All right, I see none, then.
guilty or a
Then, sir, you can step down, but hold on a second, because we're going to take a recess. The lawyers and I have some work to do
I'll skim
before we
forward.
take the next step. So it should be about maybe 15 or 20 minutes, don't know exactly, but we'll bring you back in. If it's close to lunch, we'll just recess for lunch. Hopefully, we'll be able to come back and do something else before lunch, but there's a little bit of work we have to do. You know, there's just some things,
We're going to go
there's
see-
some things that the court, the judge, and I have to do with the lawyers, and they have to occur at certain points in the trial. Sometimes they're inconvenient points for purposes of taking a break, but they have to be done. It can't be done ahead of time. It can't be done later. It has to be done right now. So that's why we're doing this right now. So we will stand in recess for about 20 minutes to a half hour, I'm guessing, roughly.
Okay, I'm going to come ahead and see. I'm going to start the next video because I know that I'm pretty sure by what I'm seeing here that they are going to go to jury. Okay, so we're going to bring up this video. I'm going to share this screen. We're coming back in. This is after their break. Let me turn on the sound, and here we go, y'all.
All right, we're back on the record. The record will show that jury is absent, counsel is present, counsel are present, as well as the defendant. The court has reviewed state's proposed exhibits 143 and 144. 143 is a transcript of recorded interview with Miguel, who has been identified.
Mike?
141. Did I?
Okay,
Did
you
I
said
make-
144. I just wanted to make sure we were
All
talking
right.
about the same thing.
Oh, thank you. Appreciate that.
Well, it was
Law enforcement
141,
interview
142, 3,
between
and 44.
Miguel and
It was all of it.
who were the other participants? Was that from the sheriff's office?
141 was Detective Barba and witness Ramon Felix Gonzalez.
Oh,
All right. And 141 was, well, it says Aaron Felix Gonzalez.
It's Ramon Aron Felix Gonzalez, Your Honor.
And that was also with the sheriff's department.
so they want to use
All right.
evidence
State
as
seeks to
rebuttal.
use these transcripts, play the recordings of the law enforcement interviews with these two witnesses. Neither of these two witnesses have ever been subject to cross-examination
So they can't do
in
it.
any manner by the defense. Is that correct?
That's correct.
All right.
These are the two witnesses that never showed that.
So
never became a
state seeks to
trial.
use these statements
You can't.
for the purposes of redirect or rebuttal evidence. Neither the court's going to sua sponte raise an issue. Neither of the parties has raised it to the objectionability of these two particular interviews. In Crawford versus Washington, 124 Supreme Court, 1334, United States Supreme Court, 2003.
State's gonna lose this one.
United States Supreme Court looked at a situation, fact pattern, nearly identical to this situation. The court ruled that it's a violation of defendant's Sixth Amendment right to cross-examination, to
Yep.
admit hearsay statements, even if they're under a well-founded hearsay exception under the rules of evidence. It's a violation of a defendant's Sixth Amendment right to introduce hearsay statements that are testimonial in nature, that are offered for the truth of the matter
She's getting
asserted.
ready to argue it.
Because it's not subject to cross-examination. It's a Sixth Amendment question. It's constitutional. It's the same fact pattern as this. The witness in that case in Crawford from the United States Supreme Court case gave a statement to law enforcement officers that was incriminating of the defendant, and the prosecution sought to use that and did use that. Court ruled that that statement is testimonial. It's very clear from case law, from the Crawford case and all case law that has discussed it since then, as a statement of this nature to law enforcement is testimonial in nature. It falls squarely within the Crawford decision. The use of this particular statements would violate the defendant's Sixth Amendment right to cross-examine confrontation of these two witnesses. It hasn't been raised. I'm raising it sua sponte because if the court were to allow this, and if there were a conviction, I have no idea what the jury's going to do. I'm not even speculating on that. But in the event that there were a conviction and the court will allow this, I think it's fundamental error that would result in a reversal and a remand back to this court. So for those reasons, and if you want me,
Well,
if the state
yeah,
wants to
Fair.
mark
The
these,
the
have
defense
these included as part of the
cannot
court file but not
cross-examine.
exhibit, I'm
can't bring it
happy
in.
to do so.
Yes, Judge, we'd like to do that, and that would be with exhibits 141, 142, 143, and I believe we have the 911 calls marked too, Your Honor. But before I get to that, and I'll give you that.
What's 142?
It's the actual recording that the state intended to play.
Okay, very well.
That we have synced to the transcript. We also have the 911 calls, which we would have requested to play as well. I'll get
So
to
they
that in
can
a
make it
minute.
a part of the
But
court
with
file,
response to
but
the
they
confrontation
cannot
clause
bring it
issue,
in as
Your Honor, that was
testimony.
directly addressed in the Prazer-Fong case.
I think the defense, I think the
And,
prosecution's going to,
What the court
Rest
said
for
in that
rebuttal.
case, first of all, the state's not offering the statement itself for the truth of the matter asserted. We're offering the statement for the purpose of rebutting the defense's argument that the law enforcement officer's investigation was inadequate. That's the reason they.
It was
indicated
inadequate.
They offered them for two reasons.
they're
Because they
desperate.
believed they were false and because the state's investigation was inadequate. And so that's directly on point with the Escalante Orozco case and directly on point with the Prazer-Fong case. And what the Prazer-Fong case says is that when the defense offered part of the statement, they waived the confrontation clause issue. And that case is the 2005 case in Arizona, Your Honor. And so for that reason, the state believes that
He's not going to let
statements
it
should
in.
be
'Cause it can't be
admissible.
crossed.
And I'll
Well-
get the other
Exhibit numbers.
number.
All right, well, I have 141 and 143. I'll give these to the clerk. These are not admitted exhibits, just to be clear, and they're to be made part of the court file
And I have
for whatever
142.
purpose.
I have 142 here also, Your Honor.
Very well. But
Are we making that part of the record as well, just for the record?
that's the recording itself.
Yes,
142 can be made part of the record, but not
thank
admitted.
you. And I'll find the
And
recording for the
144.
911 and let the court know what that is, so we could make that part of the record as
Which
well.
911 call is that?
There's all the dispatch calls with the individual known as, who identified himself as Miguel.
Oh, right. All right. But I mean, obviously, clearly that if either of these witnesses were here and subject to being called and subject to being cross-examined live in court, it would be a different thing because they'd be subject to cross-examination.
But they're not.
Obviously, they're not here. I'm sure they're not here. One of them, both of them are
Right, but the
parts
problem,
unknown. So,
right, but the problem is the defense offered the pieces of their statements that they wanted to offer. The state was never able to rebut that and then claimed the investigation was inadequate, and the state didn't get an adequate opportunity to rebut that. That's the state's argument. That's why we're arguing. We're prejudiced in this case.
free to argue it, make your record, appreciate that. But I feel that this is a very clear.
It's not going to
admit
hold
these
up on appeal.
particular recordings of statements by these
Only one
witnesses who are not
appeal.
here, not subject to cross-examination, and
Only the
therefore not
defendant.
we're not able to fulfill and accord satisfaction to the defendant's Sixth Amendment right to cross-examine and question these witnesses. And I've read these statements, and they contain a lot of information that is highly prejudicial. And for whatever purpose, if they're not offered
I
for
wanna
the
see
truth
it.
of the matter asserted, I think it's even a larger violation of the defendant's Sixth Amendment right to permit that to be done. But you made your record, court's ruled, not going to permit those two
Move
recordings to
on.
be played, given the Crawford case and the Sixth Amendment analysis that the courts applied to the case.
Your Honor, and the other exhibit number is Exhibit 144, if that could be made part of the record as well.
So granted, so ordered.
It's okay to be part of the record, but
Okay,
you're not going to bring it in front of the jury.
So, Mr. Jetty, you spoke before, so where does that leave us?
Or I'm getting
state
sassy. I'm
restaurant.
tired.
No rebuttal witnesses. Right?
Happily.
Very well. So what we're going to do is I'm going to bring in the jurors, the state can rest.
Bring the
And then I'm gonna tell
jury.
the jurors we're gonna need, I would estimate about an hour to finalize final jury instructions, get them copied and printed out.
Jury.
Come back, I'll give
instructions
final
are
jury
very
instructions. That'll probably take,
important,
I don't know,
will
well,
not review jury. I
do
may
you think,
not
Denise,
stay
about
for the
45
jury
minutes?
instructions. We'll see how spicy it gets.
45 minutes at the most. And then we will
If it's less than
probably recess for the
45 minutes,
afternoon, come back
okay.
tomorrow for closing arguments. Counsel, the court's gonna limit time and closing
Jury
argument to
tomorrow.
90 minutes per each
Verdict
side.
Watch.
That should be plenty of time. And the state will have 90 minutes as well. The state can watch the clock and reserve whatever time from the 90 minutes for you think might be necessary for rebuttal. Fair enough?
Your Honor, I think since we have the burden, I'd ask that we have additional time for rebuttal.
No,
That would be our request.
you
I'll take that under consideration.
Thank you.
wait a minute. You've taken 3 freaking weeks plus, and the defense has had a day and a half. I think you've had plenty of time, my dear.
You're welcome. All right, let's, anyway, that's the plan. Let's bring in the jurors, please.
And Your
One
Honor,
thing that
I
was
think the
not
further record on
shown
that is that this has been a 4-week trial. I don't think that 90 minutes is adequate to
Well,
cover.
I think this jury has had the facts presented to them. The jury has had the facts presented to them, and they understand what the facts are. I think it's more about arguing the facts and how they apply to the law.
Longer
I
than
mean,
you
all of the
should.
salient facts have been produced and
You had plenty of time.
repetitively. So let's just leave it at that.
Sorry, y'all.
Not to mention
I
the
don't
fact
think
that
you
the
heard that.
parties had opening statements that were
Ma'am,
somewhere between an
you-
hour and a half and 2 hours each, which basically laid out the entire case in the
You
beginning.
had 2 weeks extra. The jury has heard enough of you.
Sorry, y'all. I'm having fun playing. One thing that y'all did not get to see was that Mr. Kelly did affirm the statement that he was not going to testify. He waived that right. He made it very clear that, I mean, that was not shown to us, so we did not see that, but It is in court record.
Please be
Which I have in
seated.
front of me.
Record will show the presence of all the jurors, counsel, and the defendant. Good afternoon, ladies and gentlemen. Let me tell you where we are, what's going on, and what's going to happen
Beginning the
next.
case
Well,
tomorrow.
first, I'm sorry.
Hold up tomorrow.
Does
How
the
long
state
is
wish to
the
present any
hearing?
evidence in rebuttal?
Deliberate.
No, Your Honor, the state's
A
present.
person who puts the
Okay.
closest time wins.
State's
the prize
rested.
from me.
What does that mean? All the evidence is now in. State's presented its case in chief. The defense has presented its case. The state is not going to present any rebuttal case in chief. All the evidence is in. So what I need to do now is meet with the lawyers. We didn't do it over the lunch hour. We took a break. I need to meet with the lawyers. We need to finalize the final jury instructions. We've already been working on it. They have drafts and they've reviewed them. We've been working on them. Once again, so I'm going to have to send you out, but I'm explaining why. Because this is, again, something I can't do with the lawyers until everyone's rested and all the facts are in. Couldn't do it before. We kind of started the process, with drafts of the jury instructions, but now we've got to review it to make final instructions. We'll have Jose here in the courtroom. We'll make those changes. He's been warming up his fingers. So that gets done efficiently. And once that's done, we'll copy them off. You'll come back in and I'll redo the final instructions just the way I did the preliminary instructions. Then given the hour, what we'll probably do is recess for the day. We'll come back tomorrow at 8:30. And when we begin at 8:30, we'll begin closing arguments by the parties. And following the closing arguments, I'll give you some very brief final jury instructions about what to do when you go back there. And at that time, we'll pick the 4 alternates, assuming we still have all 12 jurors, and then you'll begin your deliberations. So the case will be submitted to you, likely for deliberations tomorrow afternoon. So I need to meet with the lawyers. So what I need to do, I'm sorry, we got a little bit of a gap here in time.
We're gonna fast forward. I think the jury is out. There they go. Everyone stood up. They're sitting down. Y'all, if you want me
Legal
to
discussion here about the proposed jury instructions. We do it off the record, and then we go on the record to preserve final objections that the parties may have. You're welcome to stay. You're welcome to go as well. This is usually not one of the more interesting parts about the process, but if you're interested, thank you. You're welcome to stay.
In other words, you're free to
As I
move
said,
about.
I told the jury it should take about 45 minutes or an hour to get this done. So we will.
We're going to actually.
We go off the record for purposes of the court reporter for now, and you're welcome to keep the camera running. You're welcome to stay, but
Okay, we're
fair
speeding
warning
that
to
up
you.
a little bit.
Okay. We got Jose. We have counsel, and we have the proposed instructions.
Your Honor, may I ask a question?
Yes, ma'am.
Can we all participate or only
Yes.
one speaker?
You can all participate.
Thank you,
It's
sir.
very informal.
Thank you.
Thank you for asking. Okay.
If this is
You know,
too
the
fast,
first-
let me know.
Several pages are all standard instructions.
Can I
I know there was
have a
a-
concern about the first page?
Okay.
And I know that I'm coming from a different jurisdiction, but I do have a issue with the fact that the jury is required to determine what actually happened. If we were to give them that instruction, then because of the uncertainty of a lot of facts in this case, they will be deliberating a long time trying to figure out who did what and trying to solve the case, which I don't think anyone can, in my personal opinion. And I feel like it's not the right burden.
I agree with you. No one's ever brought that up before.
Thank you. She looked at me really weird. I'm just kidding.
But it's usually, but no, their job isn't to determine what happened. Their job is to determine what the facts are. So
Thank
it
you,
said we can change that to you as jurors are the sole judges of the facts.
Yes, sir.
Period.
Okay. Are you with us, Jose?
I don't know where we are, Your Honor.
First page.
Page 1.
I'm lost. Page 1, my dear. We just
Is
started.
this not the Raji?
It is, but she makes a good point. So Raji recommended, and I think she makes a good point.
I would object. I'd ask that we use the Raji that we've
Of course
used
you
for
would.
decades.
Understood. Raji are, I think they're recommended. I think that's what the R stands for. So, or maybe it's revised. I don't know. Anyway, are you with us there? So it's the end of the second paragraph. You as jurors are the sole judges of the facts.
And actually, the first sentence of that
They
second
get on the
paragraph
horse.
also says you have to determine what actually happened.
Okay.
Same objection, Your Honor.
Mary, who is? Hopefully not the judge.
So look at the second paragraph, the
Good
first sentence.
judge.
It is your duty to determine what the facts
Have a
are
bad day,
in the
Mary.
case by determining
I'm
the
liking
facts
him.
instead of, and take out what actually happened.
Prosecution is the,
And then the same thing
Hours?
at the last sentence of that
yeah, it's
paragraph.
almost 3. The
I don't even
prosecution
think
is
that
the
first
yes.
sentence makes sense, Your Honor.
I think if we
I
just
can't
read it
cuss
off
after,
at-
until after 2
I think if
hours.
that
Yeah.
first
What the
sentence of the
facts
second
are.
paragraph,
Okay.
it is your duty to
Don't worry, I
determine
won't
what
be
the
doing
facts
much
are in
of
the
it.
case, period.
Good, okay. So that sentence,
Mary,
that sentence
who was? He's correct right now.
You got that? Good, all right. Anything else, let's say through pages 5?
And I was wondering in that, just on that same page, it just might be a little bit better, but not mandatory, but the last paragraph, the second sentence, as you determine, I just wanted to know if the court would consider review the facts.
We're on.
Pardon?
I think it's fine the way.
Okay, that's fine. I'm
It doesn't,
okay.
it doesn't change the.
She's won
content
one,
the way
she's
your other-
lost one.
I have no
The meaning, the way your other suggestions,
Thank you for listening.
of course. So
Sounds like everybody's
let's
coughing.
see, through page 6, 7, or any, stop me if you. I know we had 2 different
Hey,
instructions
welcome
here, depending
for
upon
joining
whether.
those who are joining us. We are now in jury instruction
Judge, and I think burden of
phase of this trial. Both sides
don't-
have rested,
I'm not sure if council.
and we will be going to jury in this
On page
Tell me what
10,
page
tomorrow.
I don't know. if we-
I will be live.
Oh, we're on page 4.
Please come and join me. I will be live.
What's the question about page 4?
I think this is 2 instructions in one. Is council asking for both? I don't care. I just want to make sure the record's clear.
So
Yeah,
we,
I'm asking for the whole thing.
right, there's 2 different instructions on burden of proof, but we'll give them both.
Fine.
All right.
Those of you who are just joining me, thank you so much.
Stipulations.
This is my second 3-hour live today, and actually, I've been
I
live
don't
for
recall if we
9
had any
hours now.
stipulations, so I don't know if we need
We didn't, Your Honor.
the stipulation.
But this is a very interesting
That's page
case.
10.
Actually, I think it's.
So Jose, we just take all of page 10,
setting-
that whole instruction
precedent
stipulation.
setting case.
Agreed?
Can't say that right. I'm tired.
I also don't know if we have redacted exhibits.
Very important
We do.
case for all
The
bordering
text messages.
states to Mexico,
Oh, okay.
except
So
Texas.
we'll
Texas has to
11
stand
in.
your ground.
Um,
Arizona does not.
And I
This
think
case
this
never would have made it in
testimony
Texas. I
tomorrow.
guarantee you that.
So defense, I assume you want us to leave? Well, I don't want to make any assumptions. Page 16, defendant need not testify. Do you want
Leave
that?
that in, yes.
Leave that in. Okay, sometimes people don't. And then we'll take out,
very
so
important.
Jose, we're going to page 17. That'll come out. Defendants, you
It's
must
okay if
evaluate the
y'all
defendant's testimony. the same
bugger
as
out.
the
I understand.
witnesses,
I'm
right? That
I'm
comes out.
going
He
to
didn't
do this
testify.
because some people are
Okay.
interested in this.
Um,
I am streaming on 2 different
18
channels, both YouTube and
18
Facebook at the same
stays in,
time.
correct?
But good night for those who are leaving. Thank you so much for joining me. Please come back tomorrow for the verdict watch. I
Witnesses
will
prior
keep it on
conviction.
as long as I got coverage.
Cooperating witness had a prior
As soon
conviction.
as I have
correct?
something, if there's not a live
So
coverage,
assume the state wants that
we
in there.
will be reviewing some videos of that
That's
sheriff
page
who
19, so
was
that stays in.
being an idiot.
Right
We're
now-
going to go through and review some of the
Is there anything before
testimony. We're
that?
going
Page,
to
look at
review
page
them all
20. There's the one-
while
We
they're
don't have a
doing
page number.
deliberating.
What's the heading?
I don't think they're
evidence
going
for
to take
limited
long.
purpose.
I will have a competition.
Right. I think
Tomorrow,
this would both deal with the text
Whoever gets
messages, so
closest to
I
the
would
time
prefer
it
the
takes
next
for the
instruction on
verdict to
other
come in
acts.
will win a
Your Honor,
prize.
I think we
from
need
it.
evidence for a limited purpose for multiple reasons. Detective Barba's testimony regarding all of the other witnesses, the court allowed that only for the limited purpose of determining whether their investigation was appropriate. In addition, there were 9 photographs that were photo lineup that were admitted only for the purpose of determining whether law enforcement did an appropriate investigation. In addition, Your Honor, there was the impeachment of Detective Raul Rodriguez that again was only offered for the limited purpose of determining whether the investigation was appropriate. They were not offered for the truth of the matter asserted. Those are very important instructions for the state.
But I think there was a number of times I gave limiting instructions on hearsay and otherwise, so.
So what
Yeah,
do you
that-
fill in?
So here's what, let me tell you the language I
Judge was
propose to
really
use.
good about
okay?
that.
So I think we do need the instruction.
Leave it.
During the trial, the court admitted evidence for a limited purpose. In connection with that evidence, the court gave you a limiting instruction. That evidence was admitted only for the limited purpose that the court stated at that time.
Judge, and I don't think you gave that limiting instruction with Detective Rodriguez, and I would ask that we are specific with the jury. I think the jury needs an instruction in the back reminding them of the limiting instructions. I would ask for that with respect to all
So
of
this
those
is-
issues.
Well, I mean, I gave limiting instructions. We just reviewed some of them. You did as well,
Mhm.
in a number of different contexts and different types of limiting instructions, hearsay and the other things.
He gave a lot more
you know, I don't
instructions
wanna
than any judge I've ever.
Confuse the jury or give them excessive information by going through each and every example or situation where the court gave a limiting instruction. You can argue that to the jury if a limiting instruction was or was not given with respect to
Not.
certain evidence.
And
But
Your
but
Honor,
I'm not, what are you asking me to do, to give an instruction that I did
not.
not give a limiting instruction?
I don't know
on
what it
Detective
is.
Rodriguez?
I'm asking you to clarify for the jury what the purposes of the limiting instructions were, specifically with Detective Barba and Detective Rodriguez. I think they need that in writing specifically, And I believe it's very
I
important for
think
the
you're
state's
scared
case
about
that we
the
make it clear
testimony.
that that testimony was only for the purpose of determining whether the investigation was appropriate. And I don't think the court gave the limiting instruction during Detective Rodriguez's testimony. And so I believe that's extremely important with respect to Detective Rodriguez's testimony.
If I didn't give it, no one
Duly
asked for it.
noted.
I'm not going to do that. You can state your objection on the record. I think that's more information, more detail than is appropriate for a jury instruction in a case such as
You
this,
can't do
4-week
that.
trial, different types of limiting instructions. You're welcome to argue to the jury the court gave you a limiting instruction or didn't give you a limiting instruction as to a particular testimony. And when you argue the case, place it in that context for the jury. But I mean, I guess I haven't heard from the defense. Do you have any objection to the language as proposed?
No, that was good, Judge.
Right. And again, you'll be able to,
no,
when we go on the record,
helps her.
both parties will be able to make formal instructions. All
We
right, so
both
Jose,
object.
I'll give this to you when we break, okay? And you still want the other act, oh yeah, we kind of run out of page numbers. You still want the next instruction, which is other acts, correct?
I think that only applies to the text messages, but give us one sec, Judge.
Sure.
I will be doing the sheriff serving and living on the U.S.-Mexican border tour, both sides, U.S. and Mexico. This sheriff,
Could you reread one more time what you're proposing on the other one?
course.
Limiting instruction.
I'll be going over
Evidence
that
for a limited
tomorrow.
purpose. During the trial, the court admitted evidence for a limited purpose. In connection with that evidence, the court gave you a limiting instruction. That evidence was admitted only for the limited purpose that the court stated at the time.
My service dog keeps telling me it's time to go home, y'all. We'll be done.
I don't think we
shortly.
need this one since you already provided
Not
that one. I
gonna
was
take
just
too
thinking
much
of the
longer.
text messages, but I think during trial you provided a
you for
limiting
holding
instruction
on.
regarding those as well.
You're talking about the other acts instruction?
Yes, so I think we could take that out.
State's position?
On the other acts evidence?
On the other acts instruction?
No, I think it needs to come in as well. I think they both need to come in.
Back and
I think
forth.
the other act, I'll give the other acts instruction. If you want to make an objection to that, then.
Oh,
Then we go back on the
prosecution is so not happy. She's
All right,
throwing
separate
attitude.
counts.
She's rolling eyes and
Then-
going,
We go, then there's a couple of final instructions, the jury foreperson in closing.
Judge, there's
But-
one before that the state's requesting, and that's standard instruction 44, which is the motive instruction. I didn't see that the court included that, and I would like the motive instruction added. I can email it to your JAA if you'd like.
What's the defense position?
this prosecution has really struggled.
We're okay with that, Judge.
All right, if it's fine, then there's no
They
objection
have
made, so I'll
lost,
give it.
I would say at
If
least
you'll email that to
90%
Jose.
of their
It's very
objections.
short.
Read it, of course. We like to read it too.
Sure, it's really short. You know.
I'll
Well,
include
email
the
it.
defense, of course, as I'm ethically required to.
Okay. So what I was then saying is we go into, these need to be just reorganized. There's some closing instructions and we'll take those out and those will go, I'll read those, thing about the jury foreperson and the closing instruction. I'll read that after your closing arguments.
Mary,
So then we're going to go to the statutory
state
definition.
prosecution gets 3
of the
weeks.
elements.
Defense gets a whopping day and
So
a
looking
half.
at the first one that says second degree murder.
I want to hear this. I feel like I made my lip gloss. It's on the prosecution to prove
Judge,
beyond.
the only thing we had on that were some
reasonable
punctuation
doubt
issues.
Guilty.
And it looks like the new second degree murder, I think it's now has some brackets. I'm looking at page 33. Is that what the court's looking at?
No, I'm just looking at the one that says second degree murder, the crime of second degree murder requires proof of any of the following. It just says the elements. There's no-
Your Honor, I would have had knowingly under number 2 instead of new, but that may be just your state. I don't know. But everything is intentionally, knowingly, or
She's correct on that.
they're all recklessly. And that one just says no. I just thought knowingly would fit better.
Yep.
And Judge, I think this tracks the statute.
Yeah, I think so too.
Okay, and that's something I'm not aware of.
That's fine.
And
All right.
Renner, we got a new set from the JAA for the end of your jury instructions. So I think they've been redone already. And he included some bracketed
I know.
language as well.
We're gonna get to that.
Okay,
But
it's
the one
same
that I have, the
instruction.
second degree murder is just the Raji, just from the,
Right, but
it's got 1 or 2 or 3.
it's the same instruction. It's just later in your packet. It's the exact same instruction. It just has additional bracketed language.
Oh, yeah. Let me see.
So now they're arguing over that little fact.
All right, what do I?
It's on page 33 of
It
what
is up
Jose gave
to
us.
the defense. I mean, it's up to the prosecution to be
I understand.
prove beyond reasonable doubt. The
Looking at
defense
something.
doesn't even have to put on a case. They can say, we're done.
Because I just want to
Okay.
make sure we were all on the same page.
It's all on you. We're not going to
Is it-
bring
I
any
don't think I have-
witnesses. They don't
I
have to do anything.
This thing you just gave
It's
me.
every proof of the burden is on the prosecution. I was upset when the judge was limiting, but if the defense is happy with their defense and it was only a day and a half, so be it, it's fine. I think sometimes it's best for defense to not push and fight and pull and go on and on and on and on and on. If they can put that reasonable doubt in a few people and get in and get out quick, it's going to leave with me, my personal humble opinion. If I'm on a jury and the defense was bam, 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 done, and the prosecution took a month,
And I sent that
I'm
instruction to
gonna
Jose, so
question
she's
that.
putting it in there.
Sometimes less
Motive
is
instruction.
more.
Yeah, the motive one.
And that's my humble opinion. Sometimes less is a lot more. And I really like how these two lawyers, I mean, they did ask a lot of questions. And cross-examinations especially, and people who especially work for the state and in the legal field and whatnot, they know how to
It
testify.
substitutes the initials of the deceased, right, for another person.
Yes, Judge, and there were some typos and some
What about-
formatting issues as well.
What about
And
the
the person
one,
got
what about
typo.
the first one?
When I
that has
witnessed
GCB?
in a case,
I don't,
I witnessed in my
I think we could
ex-husband's
put
case,
Gabriel's name in there.
I
Gabriel
was-
Cuen Buitimea.
I was well
I don't think
prepared.
it needs to say.
And one of the things they told
So I
me
think
was,
putting the victim's name in is appropriate.
if this is not a yes and no answer, and you can be vague
Then
and
there's-
Defendant caused
talk about it, do it
crime of
until they
second
pin
degree
you
murder
down.
requires
And
proof of
that's
one of the following.
exactly
Defendant
what
intentionally caused the death of
was
GCB,
done
or
on the
the
state
defendant caused the death
when
of
the
GCB by
state
conduct
witnesses were
which the defendant
cross-examined,
knew would cause death or
which
serious
takes
physical
up a lot of
injury,
time.
or
It wears
under
down the
circumstances
defense. It
manifesting extreme
works
indifference to
them.
human life, the defendant
Don't
purposely
make
engaged in
it easy
conduct
for them.
that created a grave risk of death and thereby caused the death of GCB. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. I mean, that's
Yes.
the instruction.
Yes, I don't have any objection to the instruction, Your Honor, just some formatting issues. I just wanted to bring to the court's attention that we had this twice
Okay,
in the
good.
packet you sent.
All right, so that one's okay.
Just that I would ask that we move the or up to the first line, and that we would put a semicolon in the second line, at the end of the second
She's
line.
making this as
The number two.
grammatically perfect as she thinks she knows
I'll go
how.
over that with Jose.
This
We'll go over
woman
that later.
is a taskmaster.
And then there should be a period at the end of number 3.
And that's probably true.
Good.
When it came to the evidence,
That was
she
all I
was
had on
ordering
that.
everybody around,
All right,
including
what
the
about
defense, on how to
The
handle
next
it.
page,
It's like,
aggravated assault.
Your Honor, I feel like we left out the name of the victim in this, and I propose that we put it at the end of number 2. The assault was aggravated by the following factor: the defendant used a deadly weapon or dangerous instrument against, and then the victim's name. Nowhere in there are we identifying the victim, so the
and you
jurors
need
will
to
be
identify
confused
the
which
victim.
one's the
That's
victim in
important.
this
That's a
one.
good suggestion, even though
Okay.
I don't
Even
have
though
an
here's a
objection.
defense.
I would add it to number 1, Your Honor. The defendant committed an assault on Daniel Ramirez.
But it's and.
On Daniel Ramirez, and the assault was aggravated by the following factor: the defendant used a deadly weapon or dangerous instrument. And then also under the
yeah, there's
assault
2
definition,
charges.
I
Hold
would,
on, let's get to, how
This
about
is the
that?
second charge you're talking about.
Defense, the defendant committed an assault on Daniel Ramirez, comma, and,
Daniel was not touched.
does that work?
They're saying because he fired the
And the
weapon
assault-
in the air that it was an assault on Daniel. Daniel was not touched. Daniel was illegally on his property, illegally in the United
I'm
States,
kind of
and
off
is
the
most
top of my
likely
head,
the
I'm just
shooter of the victim. I'm sorry.
It seems there needs to
Not
be
sorry.
something to explain to the jury that he would have to use the deadly weapon or dangerous instrument against that particular person in order for that to be.
How about the defendant used a deadly weapon or dangerous instrument during the assault?
I don't have an objection to that, Your Honor. I don't think it tracks the statute. I think it's unnecessary, but I think adding on Daniel Ramirez is fine. And I also think,
Adding Daniel Ramirez, I mean, I take your point that it's, so they're not confused about,
And once
the
again, the
victim was
lawyer
in
in
that
pink is
particular
not of
charge.
that state. The lawyer in the
Right. The
black
name
on
is
the
both?
defense side, the young lady, is.
And Your Honor, I think
So
we
she
could
has a
add it
different
again down in the
perspective from a
assault. I
different
would
state.
ask that we not add it to the deadly weapon portion, but intentionally put, instead of another person, we could say Daniel Ramirez.
So what I'll say is then, under it says assault, the crime of assault requires proof that the defendant intentionally put another person, and then I'm going to put in parentheses, Daniel Ramirez, in reasonable apprehension of imminent physical injury. Okay?
Yes.
Then we have definitions: knowingly, intentionally, intent, recklessly, reckless disregard. Those are all,
And just, I'm sorry to go back, but I don't think we ever cleared up whether we were going to use Gabriel's full name in the second-degree murder. The state is requesting that we use his full name, Gabriel Cuen Buitimea, instead of the initials.
I'll leave that to the court.
okay, full name. All right, and we'll go over these. Jose, we're going to go over these.
And if, just to be consistent, if we're going to use full names, when we go back to the aggravated assault, we'd ask for Daniel Ramirez Ruiz, AKA Daniel.
See, this is what starts to happen, okay?
Well,
And we're trying to get this done so we don't keep these people waiting here all afternoon for changes in semicolons and stuff like that. If there's something really substantive, let's raise it. Otherwise, I really don't want to hear it. You know, if it's something that substantively changes the actual instruction, clarifies.
They know
this,
who they're
maybe,
talking
you know,
about.
we're not gonna-
I don't
a lot
disagree
of
with
this
him.
is, I just put Daniel Ramirez and we'll do that. It's just to make sure there's no confusion between the two victims.
That is
All right.
true.
And if you want to make an objection on that, you can do it. All right, so then we go into the definitions. Those are all standard. Anything
Your Honor, we're missing physical force, the physical force definition.
Where did he do physical force on
We have
anybody?
deadly physical force, but we don't have physical force.
All right, do you have that? You send it to,
I do, Judge.
send that to Jose, send it to defense counsel.
There was no physical force
It is
of
in
any
there?
kind.
I
Where's
see
that?
physical injury, but I don't see physical force.
Oh, yeah, it is up there.
Where is it?
It's on the top of the next page. Yeah.
Where?
Y'all,
That's
jury
right.
instructions are so
That's not a
vital. They are
definition.
just
That's
as
actually
important
the
as
instruction
witness
on
testimony.
justification.
This hair is driving me crazy.
What's in the one I have?
I had a
Definition of
salon,
deadly physical
a
force.
lady in
Deadly
the salon,
physical
not my
force means
normal
either
person,
force
who
which is
actually
used for the
cut my
purpose of
bangs
causing death or
and left that much
Right, it's
right
not
there.
the deadly
and throwing
physical
out
force
driving
we're
me crazy.
missing. It's physical force
Oh.
we're
It's
missing.
so vitally important to get
Oh, I
the
got
jury
you.
instructions right.
So would you
because
like me to
that's
email
the
that one?
Yes.
difference between
we
innocent
need
and guilt.
Physical
It has to be right.
force.
But you know what? I feel so sorry for these people. Sitting right behind the attorney right here
Now, then,
is Mrs. Kelly. This is Mr. Kelly, and I believe that.
anything else about the definitions? Until we get to causation, ignorance of fact. So the next,
I don't think
the
dangerous
next
offense-
series of,
I don't think dangerous offense.
78
should be here,
years of
Judge.
age.
That's for the aggravation phase.
Yeah, I agree.
oh, okay,
So that one needs to come out.
thank you. All right, out. Good. So the next series of instructions are all defense requested instructions concerning justification.
I really hope that when this is over, especially if he's found not guilty, which I believe he will be, I hope they can
I sent the
rebuild their
physical
lives
force
and live
instruction, Your
what's
Honor.
left of their life in peace. I hope they don't have to sell their ranch and move
These are all
away.
defense instructions. There's one
But I understand if they do.
line to
They
be
built
filled
a
in. I'm not sure
beautiful
what
home.
that is.
Worked
Is the
hard for this all
causation
their
ignorance
lives.
of fact, is that a Raji? I'm not familiar
And if
with
I
that
was
one.
found innocent and I could sue, I'd sue the pants off of these people. Shouldn't even made it to the grand jury. They never read Mrs. Kelly her Miranda rights. They never gave her the opportunity to not speak.
I don't think we need
They put her in the
I
back
don't
of
know
a-
that we need the causation or
an
ignorance of
SUV
fact.
and
I'm not sure why that's in there.
detained
These are-
her.
If you don't want it,
She
these are
was
ones that
not
you
free
Yeah,
to
said.
we can-
leave.
we can
She
take
couldn't
that
get
one
out because
All
you
right,
can't get out
causation,
once you're in
ignorance
the
of
back
fact,
of
we'll
those
take that
things.
out.
They drove her to the police department. She had no way to
And
leave.
Your Honor, I think so for the
Cell phone?
justification use of physical
All without a
force,
warrant.
I don't think that one applies because I don't think there was physical force used in this case. If you look at the definition of physical force,
Good for you. Thank you very much.
what it says,
That's about the only thing I've agreed
the
about what
instruction
you've
I just
said.
sent to everyone.
But
It means force used upon or directed toward the body of another person and includes confinement, but does not include deadly physical force. I don't think there's any facts in this case that Mr. Kelly physically assaulted anyone, so I don't think
True.
that definition comes in. It's duplicative of the deadly physical force one, and that one is the one that I think is applicable.
And Judge, I would just say that if Mr. Kelly is firing up into the air to try to scare people off of his property, then he is using physical force. He's not using deadly physical force. He's threatening deadly physical
yeah, I
force,
agree with that.
arguably, and also using physical force.
Look at this prosecutor.
That's not
She's
physical
so
force.
over this
I've read
lawyer.
a lot of case law on jury instructions with justification and self-defense. And they consistently say that if there's, I think the word they use is a scintilla of evidence to support the defense, the court's got to give the instructions. So I'm going to give that instruction.
I just haven't heard what the scintilla is, Judge. That's the only thing I'm looking for is we have a defendant who shot his gun in the air. It's either threatened use of deadly force or deadly force, depending on whether you believe he shot it in the air or whether he shot it at them.
Got it. You can make formal objection when you
Okay.
get to it.
Shooting
What about the
in
rest of these?
air
The defense
is
requested
not deadly
instructions. Do you
force,
want these
people.
instructions?
That's called a
Judge, and I
warning
would
shot.
argue that
Can I hear from the defense,
And in
please?
Texas,
Oh, sure.
we don't have to give a
Yes,
warning
Judge,
shot.
we want justification for
the-
self-defense.
I
Justification
mean, there's a
for
lot of other things you need to do.
self-defense
You can't just go
involving
around shooting
physical
weapons, but
force,
there is a
and
standard around
justification
here.
for defense of a third person, justification in defense of premises.
And that one, I'm just going to stop you. I don't know what, there's a blank there. I'm not sure what that was. Do you know what that was? Justification in defense of premises.
Mary, I need you to guess how long it's going to take for this
it's-
jury.
I don't have page
Come back
numbers
to the
anymore.
verdict.
It's in the middle of it's the bottom
Hours
half of
and
one of the
minutes.
pages.
Because I'm going to
The
give
first
something
line is
away.
just a blank.
What?
You have to put it in comments. If you're watching and you want to be in because it'll be good. I will send you a prize. I don't care. I'll
Oh, you
mail
have
it.
those? All right. What does it
But
say?
if you're watching the verdict, or even tonight, and you want to
What's in the brackets?
put your 2 cents worth in, please leave the comment so I can put you on the list. And the closest person to it without going over will win the prize.
That'd be helpful. I appreciate that. I mean, I don't know
It
what-
may even be a
It's
Starbucks,
difficult to work off the same, different pages. Thanks.
a new one, not a used one.
Thank you. All right, I got you.
And Judge, I would like to talk about the third person one as well before I know you're looking at this one right now, but I would
Well, the
like to
third person
discuss that one.
is his wife.
Yeah, Judge, but she's inside the house. There's no indication that anyone ever threatened her. So there's no defense of a third person here.
Well-
She's inside the house. No one ever pointed a gun at her. No one ever pointed a gun at
Her
anyone.
life is at threatened just
No,
as much
Case
as
law just
anybody else's.
says any scintilla of evidence, I don't know what a scintilla is, but it's probably 1/2 step above microscopic. We're not going to commit error by not giving instruction if there's any evidence to support the instruction. That's what the case law says. That's what I'm going to follow.
I like
And what
this.
about on this
I do like
justification of
this
defense
judge. I
of
didn't like what he
premises?
did the other day, but
There's
I
some
think he was
bracketed in there.
upset
We've
and
got it
frustrated.
select.
But he did rectify
There's
it.
a lot of bracket even above that one, Judge. I'm on 31.
Oh, right, you're right.
That needs to be fixed.
And Judge, as to this one, this is completely inappropriate. There's currently legislation pending because the legislature recognized that this justification defense does not apply in this case. The reason is because it requires that the offense occur on the premises, which is defined as the residence.
Ooh, she's getting ready to
Your
jump in.
Honor,
now.
that
Oh, wait.
legislation that she's referring is just purely castle doctrine on shifting the burden of proof. It has nothing to do with giving the ability to shoot someone out in the property like a lot of the media is saying.
Look at the
Oh, wait.
prosecutor.
It's castle doctrine.
what is there, legislation pending?
Yeah, Judge, and obviously council hasn't looked at the legislation because the
I-
legislation
It's not law.
specifically
It's not
changes.
law.
Right, Judge, but what I'm saying is the reason why the legislature is changing it is because they recognize that this
But it's not
justification
law
does not
yet.
apply
You
in
can't
this
do that
specific
if it's
case.
not law.
They haven't changed it yet, and the governor hasn't signed it yet.
I'm not saying that, Your Honor. I'm saying this one doesn't apply here because it's the definition of premises in the statute, which has
Ma'am,
been left out of the version that defense counsel provided.
you are gonna
The
get your
definition of
tongue
premises
smacked in a minute.
includes that it
You
has
don't
to
say
also include a
it
house. So
off.
they have to be trying to get into a
That's
house
not
in
law.
order for
You
this
can't do it.
justification defense to apply.
And that's
And Your Honor, to remind you that the threat came to them while they were in their home.
I guess we didn't hear
Maybe that's
that.
listen to.
Just, I had
Enough said.
Yeah, and Your
All
Honor,
right, come on, all right.
You can't do that.
Bouncing around too much. Part of it is my fault because I'm working off a different draft. Let's look above that on page 31.
You lost.
Ms. Lothar points out, says physical force, there's
It's
some
in
brackets there. The
legislation.
brackets mean
It's
there's
not been
alternative
signed
language that
into
can be
law.
used in the
You
instruction.
cannot
What
use
is the,
it.
let's go through this more systematically. What is the defense position on which of those elements should be used that is bracketed?
I'm sorry.
Sorry,
Where are
I'm
we?
sorry.
Page 31, physical force was necessary to protect another's use, attempted use, apparent attempted use, or
I
threatened
love that
use
one.
of physical force against a third person.
Yeah, it frustrates me
think we
that you
might need
cannot bring in
More than one of
legislation
those, so
that's
could
not
we do
passed.
or? So physical force was necessary to protect against another's, I would say certainly attempted use or apparent attempted use or threatened use. Well, actually, I think we need use too. I think we need all of those. We just put an or of unlawful physical force
The
against. a
defense
third.
is definitely winning most of
I
it.
think if that
Yeah.
first
What the
sentence of the
facts
second
are.
paragraph, it
Okay,
is your duty to determine what the facts are in the case, period.
good. Okay. So that sentence, that sentence is your duty to determine what the facts are in the case, period. Okay, you got that? Good, all right. Anything else, let's say through pages,
It just might be a little bit better, but not mandatory. But I mean, I just wanted to know if the court would consider review the facts.
we're on.
Pardon?
I think it's fine the way. it is.
Okay, that's fine. I'm
It doesn't,
okay.
it doesn't change the content the way
Yes,
your
sir.
other,
I have no.
the meaning the way your other suggestions.
Thank you for listening.
Of course. So let's see, through page 6, 7, or any, stop me if you, I know we had an extra, we had 2 different instructions here depending upon whether the defendant was going to testify or not testify.
Judge, and I think burden of proof.
I don't-
I'm not sure if counsel's asking for the second half of that.
Tell
On
me,
page
tell me
10
what page you're on.
I don't know.
Four.
If we, did we? Oh, we're on page 4. Yeah. I got too far ahead.
What's the question about page 4?
I think this is 2 instructions in one. Is counsel asking for both? I don't care. I just want to make sure the record's clear.
If you don't care, then why are you bringing it
So
up?
we-
I'm asking for the whole thing.
All right, there's 2 different instructions on burden of proof, but we'll give them both.
Fine.
All right.
Yeah, this lady is over it. This prosecution's like, I'm not winning anything. I'm done. I've lost most. And say here, I've lost most of my objections. I am not a happy woman.
Stipulations,
This case has been a big flop for her. Down. Try not to take sides, but sometimes you just gotta
I don't
do it.
recall if we had any stipulations, so I don't know if we need
Once again, I call
didn't,
myself
Your
the
Honor.
alternate juror.
the stipulation.
I've heard the whole case. I'm telling you my opinion.
That's
My
page
opinion
10.
is
Yes.
not
So
guilty.
Zay, we can just take all of page 10
It
out,
shouldn't even made it
that whole
past
instruction, stipulation.
the grand
Agreed?
jury.
Yes.
I think this was more of a
I also don't know if we have
political,
redacted
not political,
exhibits.
but more of
We
a
do. The
overly
text messages.
focused hunt. I don't like to use the word
Oh,
witch
okay.
hunt.
All right, so we'll leave.
I just think they got their
11
claws into one person and
Uh,
put the blinders on and didn't look out there enough before bringing the charge.
And then I think just defendant's testimony needs to come out.
All right, so defense, I assume you want us to leave. Well, I don't want to make any assumptions. Page 16, defendant need not testify. Do you want
Leave
that?
that in, yes.
Leave that in. Okay, sometimes people don't. And then we'll take out,
no,
so Jose, we're on
Mary.
page 17.
What?
That'll come out. Defendants, you must evaluate the defendant's testimony the same as any
That would be
witnesses,
record-breaking
right?
if they
That
only
comes
did
out.
that.
He didn't
If I was
testify.
you, I'd say at least an hour and 30. Got to include their lunch break.
18 stays in, correct?
Oh, yeah, that's right. It's the statements came through. other
Yes.
people. Yes.
I
Correct?
feel like I've inhaled a fly in my nose this is, y'all. I'm sorry.
Witness's prior conviction,
Yeah, I know. I'm
cooperating witness had a prior conviction, correct?
Yes.
So we'll assume the state wants that in there.
Yes, Your Honor, the victim did.
That's page 19, so that stays in.
Oh,
All right,
the
now,
state won one.
is there anything before that? I'm looking at page 20. There's
We
the
don't
one-
have page numbers.
We don't
What's the
have page
heading?
numbers.
What's the heading?
evidence for a limited purpose.
I think we wanted one out and the other one in.
Right. I think this would both deal with the text messages. So I would prefer the next instruction on other acts.
Your Honor, I think we need evidence for a limited purpose for multiple reasons. Detective Barba's testimony regarding all of the other witnesses, the court allowed that only for the limited purpose of determining whether their investigation was appropriate. In addition, there were 9 photographs that were photo lineup that were admitted only for the purpose of determining whether law enforcement did an appropriate investigation. In addition, Your Honor, there was the impeachment of Detective Raul Rodriguez that again was only offered for the limited purpose of determining whether the investigation was appropriate. They were not offered for the truth of the matter asserted. Those are very important instructions for the state.
Right, I think there was a number of times I gave limiting instructions on hearsay and otherwise, so.
So what
Yeah,
do you
that-
fill in?
So here's what,
Mary, I wrote it
let
down.
me tell you the language I propose to use, okay? So I think we do need the instruction. During the trial, the court admitted evidence for a limited purpose.
Mary.
In connection with that evidence, the court gave you a limiting instruction. That evidence was admitted only for the limited purpose stated, only for the limited purpose that the court stated at that time.
Judge, and I don't think you gave that limiting instruction with Detective Rodriguez, and I would ask that we are specific with the jury. I think the jury needs an instruction in the back reminding them of the limiting instructions. I would ask for that with respect to all
So
of
this
those
is-
issues.
Well, I mean, I gave limiting instructions. We just reviewed some of them. You did as well.
Mhm.
In a number of different contexts and different types of limiting instructions, hearsay and the other things. You know, I don't want to confuse the jury.
You don't want to
give them
confuse and
excessive
badger
information
your
by
jury.
Going through each and every example
You,
or situation where the
ma'am,
court gave
you
a
should have
limiting
made all
instruction. You
that
can argue that
objections
to the
during
jury
trial.
if a limiting instruction was or was not given with respect to certain evidence.
And Your Honor,
But I'm not, what are you asking me to do, to give an instruction that I did not give a limiting instruction when, for Detective Rodriguez?
I'm asking you to clarify for the jury what the purposes of the limiting instructions were, specifically with Detective Barba and Detective Rodriguez. I think they need that in writing specifically, and I believe it's very important for the state's case that we make it clear that that testimony was only for the purpose of determining whether the investigation was appropriate. And I don't think the court gave the limiting instruction during Detective Rodriguez's testimony. And so I believe that's extremely important with respect to Detective Rodriguez's testimony.
If I didn't give it, no one asked for it. I'm not going to do that. You can state your objection on the record. I think that's more information.
I think there it is. She did not preserve it. She didn't ask for it. She could have asked for it. That's on her. It is not up to the judge to police every single limiting objection or whatever. It's up to her to do her objecting. It's up to her to ask for it in the moment. I think this judge has babied the state more than enough. I think on one hand, if I place devil advocate on that, it helps Mr. Kelly if it ever goes to appeal. But I could be wrong. I'm not a lawyer. But the thing is that this judge has gone well and above the call of duty when it comes to explaining things. I've never heard a judge explain so much and in such a good way, an appropriate way, when a lot of times the judge just sits there and doesn't do anything unless there's an objection. I think the state is making it worse for themselves.
More detail than
I'm sorry, as pertaining to the juries and their opinion of them.
Is appropriate for a jury instruction in a case such as this, 4-week trial, numerous different types of limiting instructions. You're welcome to argue to the jury that court gave you a limiting instruction or didn't give you a limiting instruction.
You can do it in a
as to
closing
particular
argument.
testimony, and when you argue the case, place it in that context with a jury. But I mean, I guess I haven't heard from the defense. Do you have any objection to the language as proposed?
No, that was good, Judge.
Right. And again, you'll be able to, when we go on the
I'm not
record,
touching that helps
both parties
us.
will be able to make formal instructions. All right, so Jose, I'll give this to you when we break, okay? And you still want the other act. Oh yeah, we kind of run out of page numbers. You still want the next instruction, which is other acts, correct?
I think that only applies to the text messages, but give us 1 sec, Judge.
Sure.
Please. I'm trying to see if they have a break. Yeah, this is going to go on for about another 20 minutes, y'all. Thank you so much for joining and hanging in there. Like I said, the jury instructions are vital. You can have a phenomenal case.
Could you
And then the jury
reread one more time
Oh,
what
yeah.
you're proposing on the other one?
Of course.
Limiting instruction.
Evidence for a limited purpose. During the trial, the court admitted evidence for a limited purpose. In connection with that evidence, the court gave you a limiting instruction. That evidence was admitted only for the limited purpose that the court stated at the time.
Except then, yeah.
Judge, I don't think we need this one since you already provided that one. I was just thinking of the text messages, but I think during trial you provided a limiting instruction regarding those.
You
as
did.
well.
You're talking about the other acts instruction?
Yes. So I think we could take that out.
State's position
On the other acts evidence?
on the other acts instruction.
No, I think it needs to come in as well. I think they both need to come in.
Oh, she's going to fight for everything. She's
All
not
right, I
going
think
to.
the other act, I'll give the other acts instruction. If you want to make an objection to that, then you can when we go back on the record.
Oh, she just, every
All right,
time he doesn't give her
separate
what she
counts.
wants.
Then then there's a couple of final instructions, the jury foreperson in closing.
Judge, there's
But-
one before that the state's requesting, and that's standard instruction 44, which is the motive instruction. I didn't see that the
Mandy
court
Emerson,
included that,
thank
and I
you
would
for
like the motive
subscribing to
instruction
my
added.
channel.
I can email it to
Oh
your
my
JAA if
gosh,
you'd like.
thank you
What's the defense
so very much. Thank you. I
We're okay with
greatly
that, Judge.
appreciate
All right, if you-
everybody who
if it's fine,
subscribes to my
no objection
channel.
by either side, I'll give
Thank
it.
you so very
If
much.
you'll email that to Jose. It's a
Yeah,
very
once
short.
we read it, of course.
You blessed
We
me
like to read
tonight.
it too.
Sure, it's really short.
I'll
Well,
include
email
the
it.
defense, of course, as I'm ethically required to.
Okay. So what I was then saying is we go into, these need to be just reorganized.
Lay down.
There's there's
Not
some
y'all,
closing
my dog.
instructions, and we'll take those out, and those will go. I'll read those, thing about the jury foreperson and the closing instruction. I'll read that after your closing arguments. So then we're going to go to the statutory definition of the elements. So I'm looking at the first one that says second-degree murder.
It's this packet, right?
Emberton, I'm sorry.
Judge, the only thing we had on that
I'm
were some
looking through
punctuation
bifocal.
issues.
Thank you so much for joining.
And it looks like the new second-degree murder, I think it's now has some brackets. I'm looking at page 33. Is that what the court's looking at?
No, I'm just looking at the one that says second-degree murder, the crime of second-degree murder requires proof of any of the following. It just says the elements. There's no
Your
bracket.
Honor, I would have had knowingly under number 2 instead of new, but that may be just your state. I don't know. But everything is
And I appreciate-
intentionally, knowingly, or they're all recklessly, and that one just says no. I just thought knowingly would fit better.
And Judge, I think this tracks the statute.
Yeah, I think so too.
Okay, and that's something I'm not aware of.
That's fine.
And Your Honor, we got a new
learning.
set from the JAA for the end of your jury instructions. So I think they've been redone already, and he included some bracketed
I know.
language as well.
We're gonna get to that.
Okay.
No,
but
But
it's
the one
same
that I
instruction.
have, the
that.
second degree murder is just the Raji, just from the,
Right, but
it's got 1 or 2 or 3.
it's the same instruction, it's just later in your packet. It's the exact same instruction, it just has additional bracketed language.
Oh, yeah. Let me see. All right, what do I,
It's on page 33 of what Jose gave us.
yeah, but I understand. It looks like I'm looking at something different.
Once again, y'all, if you're watching, please
I just wanna Make
comment.
sure we were all on the.
How long do you think the jury is going to
Is it-
take?
I don't
I
think I
will
have-
have
I
prizes.
don't have that. In this thing you just gave me.
I will give away a prize for the closest without going over. I promise. You will like it. Just saying. Just in case you like those. I think you ought to subscribe. You might even get more. I want to thank everybody who has hung out for me. This is almost a 4-hour. I am now going on 10 hours of live today. We watched the yesterday's trial. This trial is not filming live every single day, so most of it is recorded, and then I have to play it the next day. I'm trying to get us all caught up tonight because tomorrow, they are going to jury.
And I sent that instruction to Jose, so he should.
They're
be
going
getting
to
it.
jury tomorrow.
Motive instruction.
Yeah, the motive one.
Mandy, I just subscribed to your channel. Thank you so very much, love.
All right, I see what you're talking about. I don't know what the difference is. but-
You are awesome, Mandy. Thank you.
Oh, it just substitutes the initials of the deceased, right, for another person.
Yes, Judge, and there were some typos and some
What about-
formatting issues as well.
What about
with
the
first
one, what about the first one that has GCB?
I think we could put Gabriel's name in there, Gabriel Cuen Buitimea. I don't think it needs to say of another person. So I think putting the victim's name in is appropriate.
I think they've already made that clear earlier that they were going to put the victim's name in instead of
And then
her.
there's
Defendant
some,
caused the crime of second-degree murder requires proof of one of the following. The defendant intentionally caused the death of GCB, or the defendant caused the death of GCB by conduct which the defendant knew would cause death or serious physical injury, or under circumstances manifesting extreme indifference to human life, the defendant recklessly engaged in conduct that created a grave risk of death and thereby caused the death of GCB. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. I mean, that's
Yes.
that's the instruction.
yes, I don't have any objection to the instruction, Your Honor, just some formatting issues. I just wanted to bring to the court's attention that we had this twice
Okay,
in the
good.
packet you sent.
All right, so that one's okay.
Just that
It's
I would
clear
ask
who
that
the
we
person-
move the or
Sorry, it's clear who the
up to the
person
first
is.
line,
That's
and that
the
we would put a
same
semicolon in the
charge
second line. At the
that
end
Hannah
of the second
Gutierrez
line.
Reed was found guilty
number
of
two?
just this week.
All right.
I mean, was
I'll go over that
sentenced
with
for
her.
this week. And those who
We'll go over that
know
later.
who she is, she got 18
And then there
months
should
in
be a
prison.
period at the end of
Can
number
never
3.
touch a firearm again. Cannot ever work as
Okay.
an armorer
That was all I had
again
on that.
or on a movie
All
set.
right, what about the
As a
next
normal.
page, aggravated assault?
Your Honor, I feel like we left out the name of the victim in this, and I propose that we put it at the end of number 2. The assault was aggravated by
think
the
he
following
just dealt
factor:
with
the
that. I
defendant
think-
used a deadly weapon or dangerous instrument
I think
against,
they're gonna
and then the
irritate the
victims.
judge.
Nowhere in there are we identifying the victim, so the jurors will be confused. Which one's the victim in this one?
Okay,
I don't have an objection. I would add it to number 1, Your Honor. The defendant committed an assault on Daniel Ramirez.
But it's and.
on Daniel Ramirez, and the assault was aggravated by the following factor. The defendant used a deadly weapon or dangerous instrument. And then also under the assault definition,
Hold on, let's get to, how about that?
Slow down, my dear.
Defense, the defendant committed an assault on Daniel Ramirez, comma, and,
I think by reading so fast,
does that work?
hopefully it gets it through.
And the assault.
I'm just kind of off the top of my head, I'm just thinking, it seems there needs to be something to explain to the jury that he would have to use the deadly weapon or dangerous instrument against that particular person in order for that to be.
How about the defendant used a deadly weapon or dangerous instrument during the assault?
There you go.
I don't have an objection to that, Your Honor. I don't think it tracks the statute. I think it's unnecessary, but I think adding on Daniel Ramirez is fine. And I also think,
Adding Daniel Ramirez, I mean, I take your point that it's, so they're not confused about who the victim was on that particular charge. But,
Right.
Can we
All
put
right.
the name in both?
all right,
and
so I'm
Your
gonna-
Honor, I think we could add it again down in the assault. I would ask that we not add it to the deadly weapon portion, but intentionally put, instead of another person, we could say Daniel Ramirez.
So what I'll say is then, under it says assault, the crime of assault requires proof that the defendant intentionally put another person, and then I'm going to put in parentheses,
That's why he wears the
Daniel
robe.
Ramirez,
Didn't know it, but I was a poet.
in reasonable apprehension of imminent physical injury.
Exhaustion.
Yes.
Then we
They're gonna
have
beat this horse.
definitions,
Sorry,
knowingly,
horses.
intentionally, intent,
But they're going to beat this horse
recklessly,
without the
reckless
name.
disregard. Those are all,
And just to, I'm sorry to go back, but I don't think we ever cleared up whether we were going to use Gabriel's full name in the second degree murder. The state is requesting that we use his full name, Gabriel Cuen Buitimea, instead of the initials.
I'd leave that to the court.
okay, full name.
I get what they're doing, but
All right, and
they
we'll go
know
over
who
these.
those
Jose,
initials
we're going to go
are.
over these.
It's clear. But
And if, just to be consistent,
wanna leave
if
room
we're
for
going to use
confusion.
full names, when we go back to the aggravated assault, we'd ask for Daniel Ramirez Ruiz, AKA Daniel.
See, this is what starts to happen, okay?
Well,
Oh, we've
I'm
already
trying to
done
get
that.
this
Why are
done
we
so we
getting-
don't keep these people in
My
stress.
bad, guys.
What is the, let's go through this more systematically. What is the defense position on which of those elements should be used that is bracketed?
I'm sorry, where are we?
Right here.
Page 31,
Okay.
physical force was necessary to protect another's use, attempted use, apparent attempted use, or threatened use of physical force against a third person.
I think we might need more than one of those. So could we do or? So physical force was necessary
about
to protect
10,
against
15 minutes
another's.
left. Hang
I
in
would
there,
say
guys.
certainly attempted use or apparent attempted use or threatened use. Well, actually, I think we need use too. I think we need all of those. We just put an or of unlawful physical force against a third person.
Your Honor, obviously, we're going to continue to argue that there was no use of force, there was no attempted use of force, there was no apparent attempted use of force, there was no threatened use of physical force in this case, specifically with respect to physical force, under any scintilla of any facts.
We have evidence that was reported by law enforcement officers that Mr. Kelly said he was shot at. Now, you don't agree with that, whether it's proof or not, but I mean, if there's evidence in the record that the defendant, that the jury heard that the defendant says he was shot at,
And then 6
You
minutes
brought
later,
that
he said, I
evidence
don't
in.
know, wasn't shot at. It was from another direction. I don't know what direction it came from. And then when he talked to Detective Ainsa, he said,
But
no, I don't
you
know where the
brought it
shot came
in.
from. And he's inside his house. So
On
that he's not shot at, he's inside his house.
you be shot at inside
On
your house.
all of the fact scenarios, he says he's inside his house.
can he
He
be
was
shot
shot at-
inside his house? I mean, Ms. Hunley, look, I understand what you're saying, but I'm dealing with case law from Supreme Court of State of Arizona, Court of Appeals of the State of Arizona. That says if there's any, I mean, the case law is clear.
She brought the evidence in to try to impeach Miss Kelly and Mr. Kelly vicariously that he stated to the Border Patrol agent ranch liaison that he was being shot at. The witness today said, or was it yesterday? Because they're delayed, I get them confused. But the lead investigator for this case stated that Mr. Kelly said he was shot at. Sorry, woman. You ain't getting your way on this.
Trial court must give these instructions if there's any scintilla of evidence
You
to
can be
support it,
shot at
whether
through
it's-
your
it's
window,
reversible
my
error.
dear.
And there's one interpretation of the facts that you're giving, but there's another interpretation of the facts that facts in the record that show or provide at least a scintilla of evidence that the defendant was being
Believe.
shot at. Whether the jury believes it or not, it'll be up to them.
He believed
So,
when the gunshot was
I'm not
heard
going to get led into
that
error.
he and his wife
I've done the research.
could have been being
I'm not
shot
going to get
at.
led into error because you have a
There's your
separate
scintilla
interpretation of
evidence.
the facts. All right, let's move on. I'm going to put or use or attempted
Put it on
use
the
or
record
apparent
as
attempted use or
objection.
threatened use. We're going to remove all those brackets.
But you brought that in. Now you want it out. I mean, look at that body
What about
language.
number 2, Ms. Larkin?
She
Let
is
me hear from you first.
so done
Same
with
thing,
this.
Judge. We'd asked for the ors.
Remove bracket.
Look at her rolling her head. I mean, she is like well overdone. If she was a pizza, she'd be crispy burnt right now.
All right, now the next brackets is where we were before on justification. Let me hear from the defense.
She looks like
The
she's ready to
defendant
just
in
walk out and give up.
lawful possession or control of the premises is
can.
justified in, and then there are 1, 2, 3, 4 alternatives there.
I think the same thing's appropriate, the ors, and keep
Yeah.
all of them.
See, that's the problem when you bring evidence in and then you think you can go through the jury instructions and try to skirt around it.
And then there's
Sorry.
a bracket at the bottom.
Not
It says
sorry.
the force used may not be greater than reasonably necessary to prevent the attempted criminal
She
trespass.
looks defeated.
So I'd say the attempted or actual criminal trespass.
It's like she's ready to just get it over with. It's looking good for the defense.
And then on the next page,
Once again, if you're just joining me, thank you so much. I greatly appreciate it. I made a K.
and I would say
Comment, like,
committed or
subscribe.
attempted.
I greatly appreciate it. Even share if you feel led to do so. Tomorrow
I
will
don't think
be
there's-
our verdict watch.
Council can
Join me on that
explain to
watch.
me that I'm
Comment
missing
below
it.
or tonight or
First of
tomorrow.
all,
no
hold on a second.
trespass
Just let me
in the
tell me
home.
show me where you're looking.
Before
at.
the jury,
I'm at the
before the
top of
jury
page
goes
32.
to deliberation,
And
how long
there's
you think
the
it's
very
going to
first
take?
line, there are those brackets.
Because I'm
where it says
giving away a
committed,
prize.
attempted.
Hey, Mr.
We would-
Jetty, can I have your instructions again?
To the
I'm at
closest person without going
5:32 is
over
different.
on how long the jury has to deliberate. So if you're interested in winning a Starbucks mug, please
Do we just want to make a copy?
comment
Full set?
how long
Let
you
me have
think
the
the
rest of
jury
those.
is
You can
going
just
to
go over this. I'll
deliberate,
show you the thing. I'm sorry. about that.
and you'll be
Okay.
in the pool. And if it's a tie, then I'll flip a coin.
All right, I'm with you now. What is,
Mary's in for 59
Committed, we
minutes.
just want to say committed
And
or
no, you don't
attempted.
get 2 guesses, my love. Comment posted.
And then the other bracket where it says the defense ends when the attempted, I would say the attempted or actual criminal trespass ends.
I love the body language. You can tell who's engaged and who's done. Look at the defense side. They're engaged. They're leaning in. They're reading. This
Okay.
lady flopped back and said, I'm done.
then
Look
the
at
other
this.
instructions that follow were instructions that were
This guy says nothing.
included in, I don't remember if it was the states or the defense, but in
Guy behind
anticipation
my head
of the possibility that there was a lesser included offense instruction.
on the
Yeah,
far
I
left
assume.
in the blue tie.
Sorry,
with
we'd
the
ask to
gray
take those
jacket.
out.
Negligent homicide,
homicide.
manslaughter.
We want them, Your Honor.
He is
Are
evidence
you requesting lesser included?
sheriff
Yes, we
office person.
All right, what's the offense? But state can request lesser included.
We're not requesting lesser included.
Ooh, snap.
All right, well, then we need another instruction. We need the general lesser included instruction. Well,
I think you already have it in here, Your Honor. If you look down to page 33,
Like I said, this woman is,
that what you're talking
she's a taskmaster.
And Mr. Jetty, last one he gave me was 32.
Oh, I got it.
Sorry,
Dude, you didn't give the judge all the pages?
sorry about that.
I know, it's been a long trial, and it's your fault. Those who are joining me, the prosecution took
There
over
it is.
3 weeks. Defense took a day and a half. The judge
on
was
page
not happy
33,
last
Judge?
I'm
Thursday.
there, yeah.
I think we
It
would just
was
need to
nasty.
take out that second-degree murder because it is a duplicate, but that is the lesser included from the Raji.
I think they should all go in order, Your Honor, starting with second-degree murder, then the lesser, then the manslaughter description, then the lesser of the negligent homicide.
All right, so we'll take out that redundant second-degree murder, right? And then we'll start with the crime of second-degree murder includes the lesser offense of manslaughter and negligent homicide.
Mary, I
Manslaughter.
love your post on Facebook 3 days ago
Negligent homicide.
with y'all and all the military
All right.
people giving out the penny crosses. Y'all are awesome.
Then on to 34. What about the criminal trespass? We don't.
Your Honor, and I think that what we'd need to do, these are just the lesser included portions. It doesn't, oh, no, they're in there. Never mind.
Criminal
No,
trespass.
I think we actually need to insert the manslaughter description right there where it says manslaughter on page 33. And then we would need to insert the negligent homicide instruction right under negligent homicide. Oh, that one's actually there, but the manslaughter one looks like it's missing here, unless I'm just missing it.
Second degree manslaughter. Okay, y'all just okay. I guess.
And I think the only manslaughter that applies is the reckless, so I don't think we need to say it can be committed in 2 ways.
Yeah, you don't want to confuse the jury about that one.
All right, I'll reorganize these. What about the criminal trespass in the first degree? I don't know where that.
Where was the criminal
And
trespass? on
that's
the
what
first
we're
degree?
requesting, and I think the definitions that go with it, we would just ask that we move those to be under the instruction on the
I don't know, what's the trespass one?
It's part of the justification of defensive premises.
Oh, okay.
And so that just defines those terms, and we would ask that those terms, the criminal
it.
trespass and the definitions be moved so that it makes sense for the
So
jury.
move to follow the justification.
Yes.
So the criminal trespass is in the instruction concerning the victim, I think. I'm not a lawyer. I probably should be. I could go to school and be one.
Gotcha.
I'm getting ready to start college for criminal justice. I'm going to finish my bachelor's.
We got some work to do.
Yeah, you got a lot of corrections.
Your Honor, would you like to hear my argument about the justification defense? And
Not really.
the premises issue?
Go ahead.
There is a case on point, State versus Level, 97 Arizona 269, that talks about how the trespassing has to be in the premises. The definition in 13407 says that premises means any real property and structure adapted for both human residence and lodging, whether occupied or not. So what this justification defense only applies
Again?
when someone is getting into the home. There are no facts in this case that anyone is
didn't get
getting
into
into
the
the home. That's why this does not apply.
Where does that definition come from again?
13407 subsection C. And when we give the definition of criminal trespass in the first degree, it's misleading because the definition, the justification
She may win
definition
this one.
is limited to premises. And and the criminal trespass in the first degree also has the fenced residential yard. And so that's misleading because the justification defense doesn't apply unless somebody's physically trying to get into the home. And so for that reason, Your Honor, I think
There was no
that
attempted break-in of a home
these
or structure.
instructions are completely misleading for the jury.
And Judge, the justification defense also applies to attempt. And if somebody's outside of your house with guns and shooting, it's certainly an attempt.
Well, it's a reasonable assumption.
We're going to take a
attempt by the
recess. I'm
victim.
going to get to work on these. We got a lot of work to do. And then we got to look at them and get them copied off. Hopefully we'll still be able to get to them this afternoon, but there are a lot more changes than I anticipated, but that happens. That's all right.
Okay, we're done. And they did not come back. So tomorrow we will be doing a verdict watch. Well, first we'll have court in the morning. I don't know if they're going to give that to us live. I really hope they do. If they don't, they didn't post this until like 8 o'clock, something like that. I don't know. I've been live for 3 hours. Could have been 7 something. What time is it? 12, 9. Yeah, it was like 8:30. No, 4 hours. It was 8 o'clock before I even, and I was like within 10 minutes of this thing going live, hopping on. So chances are we are not going to get the morning session unless they go live. And that's going to be a shot in the dark. But what I will be doing tomorrow is the sheriff that was on the stand today they discussed an interview he gave about surviving and living on the US-Mexico border where he referenced this case. I will also be going back and discussing pretty much kind of giving a road thus far on this case. I will do so as non-biased as possible. Like I said, came into this trial without knowing anything about it other than a rancher was being accused of shooting and murdering an illegal alien on his ranch. Because of that, I have worked very hard not to form an opinion before right now. I have been waiting through 3 weeks of the prosecutions to have the aha, that's it, he's guilty moment. Never had it. Unfortunately, every time they thought they had something, it was a flop. And it just like they just could not get a win. I will try and pull some videos. I will try and do some things like that to keep us entertained. I may not go live all day. I do have things I have to plan for and get ready for this weekend, but we will be doing a jury watch. Please leave. Oh, thank you, Mary. We will be doing a like I said, put a time down below. How long you think the jury's going to deliberate? Person closest to without going over, it's not going to be this exact mug, but I will be giving away a Starbucks tumbler. Mary, thank you so much. A blessing to give, and they are appreciated, especially when it comes from a young man. So, thank you so much for joining me. I appreciate it. For those who have subscribed, thank you. If you've not, it's only a click. It doesn't cost you anything, but it helps me. I'm a very new channel. I've only been doing this a matter of weeks. This is a very new, exciting thing. One of my plans is that I've got to order a connector so I can have a clip-on mic so I can sign and talk at the same time. So the deaf community that I am involved in and a part of will be able to see me sign at the same time that I'm talking. Not every trial has closed captioning. I can't interpret court. I'm not a court interpreter, and I'm not certified for that. But I can sign for myself and my own comments. I can have closed captionings when they have them. I can sign and give a synopsis of everything that's being said. But I cannot interpret court in any way. So that's my goal for about another week. We have, I don't know what trial I'm going to cover next. A lot of trials in the middle of trials, and that's so many people are covering, and some of them are just very brutal, and I don't want to cover them. But the Russ trial with Alec Baldwin will be in July. I will be covering that. I'm already planning on that. I'm already working on that. Okay. So thank you again so much for watching. You guys are amazing. I appreciate you so very much. And I really hope that you guys have an awesome evening and get some sleep. It is 12:13, which means it's going to be really late before I get to sleep. And I got to be back up here at 8 a.m. So with that, thank you very much. Have a great night's sleep. See you tomorrow. Bye-bye.